Good morning. Can you hear me? Hello? Hi. Can you hear me?
Yeah, I can hear you.
Okay.
Okay, good morning all. This is Judge Evans. We're here on the family law self-represented docket.
Yes, I'm here.
Okay, so we should have John Gilbert. Is that you, Mr. Gilbert?
Yeah.
Okay, welcome to you. And Miss Erin Gilbert, you're here and you can hear me all right?
Yes.
Very good. And Mr. Keith Lawrence is present. Let's see, just a quick double check for today's hearing. This is Mr. Gilbert. This is your motion for visitation.
Yes.
Okay. I've read everything that's been submitted by the parties. This is related to the child Max. And I reviewed, it looks like we had Dr. Maherg submitted a psychological evaluation of the parental risk assessment that was done on April 29th. And then there's also a report from the visitation specialist submitted on June 29th, indicating that the visits are going well. He's always early, he's always prepared, and it's positive interactions. And Dr. Maherg's assessment was no diagnosis or diagnoses, no major challenges to Mr. Gilbert's parental capacity, and no specific reason to restrict normalized visitation with his son. So that's kind of where we're at with the information that I've reviewed. And then the request by Mr. Gilbert is for to reinstate basically the June 2021 parenting plan with him exercising visitation or residential time on Friday 5:30 till Sunday at 7 p.m. and then summer with alternating weeks. That's kind of where we're at. So we'll first hear from Mr. Gilbert related to your motion, and then we'll hear from Ms. Gilbert and then Mr. Lawrence. Mr. Gilbert.
Yeah, I did everything the courts asked me to do. I proved everything that was put out on Facebook was wrong, so I'd like to just get my visits back and quit dragging this out.
Okay, thanks. Ms. Gilbert?
I mean, the only request I would have, well, I guess a couple, is that Max cannot be around Brenda. I mean, I believe that John and Brenda are separated, so I don't think that's an issue, but I just want to make sure that, or I would like to have an order, if possible, that Max cannot be around Brenda if he's with John. And also John, you know, because I think they're separated, John is staying at a friend's. And so I'm not sure about Max going there every other week in the summer. I just feel like if John's working, he would, and they're staying at a friend's house. I don't know. I just would feel more comfortable. It was if it was on the weekends when John was there full time.
Okay.
Until John has his own place or whatever.
Okay, so what you're saying is that you, as far as the alternating weekends, you're fine with that, but as far as alternating weeks, that's what your concern is there.
Yeah.
Okay. All right, Mr. Lawrence.
Your Honor, I had a chance to review Dr. Maharg's report as well as the summary submitted by Beth Fellows. John is correct. He's done everything that we've asked him to do. It appears that there are no impediments for him to see Max, and Max enjoys the visits with his father. Like Ms. Wilbanks, I also share a concern about contact with Brenda. She has been one of the primary issues throughout the involvement that I've had in this matter over the last 3 years. And I would hope that Mr. Gilbert is going to keep the two separated. As far as where he's living, Mr. Gilbert had not shared that with me, so I don't know anything about the people that he's staying with at this point.
Okay, thanks. Mr. Gilbert.
I've got an attorney, well, a couple of attorneys working on that. I'm hoping to be back in my house by the end of the month.
Okay, where are you at currently?
What's that?
Where are you at currently?
Pretty much homeless right now, staying in my truck or crashing here and there.
Okay. And then, so if the visitations were to go back to the alternating weekends, tell me where Max would be
Well, I'd
staying.
go stay up at my brother's house or something on the weekends. I have him.
Okay, and where does
go to the beach or go do something
where does your brother live?
up in Toodle.
Okay, so that's where you and he would spend the time.
Yeah, on the weekends or.
Okay, and okay, and then Ms. Gilbert, do you have any thoughts on that?
I mean, it doesn't make me feel great not knowing where he's going to be every weekend, but I don't know if I have any control over that. So
Okay, thank you. Mr. Lawrence, any thoughts on that?
I think as long as Mr. Gilbert is in attendance, I don't see an issue. He's not, other than having Max exposed to Brenda, he's not taking Max and put him in harm's way outside of the home ever, to my knowledge.
All right, thank you. Let me take just a moment to prepare an order. And then, Mr. Gilbert, as far as there's a request related to Brenda Max having no contact with her, do you have any concerns with that request? No. Okay. I'm just going to take a moment to just do a handwritten order, and then I'll let the parties know what the decision is. And then if you have any questions, you can ask.
So when we can start?
So, like I said, I'll write my decision out, and then I'll tell you what the decision is, and then we can follow up with any further questions. One quick question to the parties: as far as an exchange location, where would the proposed exchange location be for the pickup and drop off?
Castle Rock Park and Ride where it's been.
Okay, Ms. Gilbert.
I mean, I live in Portland now. I would love if it could be, you know, a middle area like Woodland or something. But
So you said you're in Portland,
yeah,
and then your
That's
brother.
where the meeting spot's always been on the parenting plan. Even when she moved to Portland, since she was the one to move them away, they still made her bring them to Castle Rock Park and Ride.
Okay. And you said your brother's in Tootle?
Yep.
Okay. So I appreciate the feedback that we received from the visitation specialist and Dr. Maherg and Mr. Gilbert going through those different procedures or evaluations and the like. And so I'm going to grant the request for visitation that'll start this weekend. It'll be on the first, third, and fifth weekends of each month as defined by Friday. So it'll be from Friday at 5:30 to Sunday at 7 p.m. Given the change of the parties as far as where you're living and where the exchange, or pardon me, where the visitation is going to occur, I think that the exchange location should be at the Woodland Safeway. So that's where the exchange will occur. Parties will meet there and do the exchange. So at this point, I'll grant that motion. Oh, and I'll also just add that there will be no contact with what's Brenda's last name?
Gilbert.
I do have one thing, Your Honor, if possible.
Yeah, go ahead.
Max's birthday is next week, and so I have a birthday planned for him this weekend. Is it at all possible to start next weekend?
Mr. Gilbert.
I've already had to miss 2 of his birthdays over this crap.
I mean, I have like his friends coming, etc. I didn't, you know.
I had my
Like
kid
Saturday.
every other week already too.
So just a quick ground rule. When one of my ground rules in the court is just when one party's speaking, nobody interrupts. So go ahead and finish, Ms. Gilbert, and then we'll hear from Mr. Gilbert.
Yeah, I mean, I have the whole party set up. So, I mean, even if it was, you know, Saturday evening or something, I could, if John wanted him for, you know, Saturday night through Sunday or something, I could do that. But I just have the party set up for Saturday day.
Okay. So, you know, this motion's been pending for a little bit. The parties didn't know how the court was going to rule on the particular issue, or how the court, what the details would be. So I think the fact that a party's already been planned, the party should go ahead as planned. So then the visitation will commence on the third weekend, which will be on the 20th. And if Mr. Gilbert would like to have that weekend visit that he's missing out on this week, then we could just make that happen next week. So for this month, it would be the second, third, and fifth weekends of the month. So that's when the exchange, or that's when the visitation will occur. I have a copy for each of the parties. Any questions on your end, Mr. Gilbert?
No.
Okay, Ms. Gilbert, any questions on your end?
No, Your Honor.
Okay, Mr. Gilbert's getting a copy of that order, and then your order, Ms. Gilbert, will be filed in the court file, and you can get a copy of it later.
Okay.
All right. Any follow-up, Mr. Lawrence?
Just whether or not the court would consider relieving me of this appointment at this time.
So relieved.
Thank you.
All right, thanks. So
Thank you.
Is Carly Salazar on the line? Carly Salazar, if you're on the line, please make sure you're unmuted and state your name.
I'm Carly Salazar.
Okay, great. Thanks, Ms. Salazar. All right. So we're here on Mr. Salazar's motion for adequate cause and a petition to modify the parenting plan. And I just want to touch base with you first, Mr. Salazar, regarding service of all the documents related to your proposed adequate cause, the modification motion. Did you provide service of all of those documents to Ms. Salazar?
Yes.
Okay. And did you file a declaration of service or an affidavit of service?
What is that exactly?
Yeah, it's a declaration or a statement by somebody other than yourself that says, hey, on such and such a date at this time, I gave these
Oh,
documents
yep.
to Ms. Salazar.
Yes.
Okay. And then when was that filed? Because I was looking in the court file and I didn't see that. I saw a docket notice where it's a family law calendar notice, say on July 3rd, we're gonna have this modification hearing. And then you sent a copy of that notice, that a 2-page document to Ms. Salazar at her Kelso address.
Mhm. I'm not sure if I actually have it here with the court, but she was served on the 11th of June.
Okay. So one of the key aspects with one of the first things I always look at on cases is I look for service to make
Yeah.
sure, because that's kind of the heart of the whole system, is that there's a notice and an opportunity to be heard, the due process concerns. So I'm pretty much a stickler on that there needs to be that all the rules are followed as far as the
Mhm.
service. And so when I looked at the file, I didn't see that the service was there. I saw that Ms. Salazar responded.
Right.
However, without that declaration of service, I think we're in a position where that has to happen first before we can move forward with the hearing. So do you have a copy of
I
that?
have it right here on my phone.
Is it a PDF?
It's a PDF.
Okay. And let me touch base with Ms. Salazar. Ms. Salazar, did you receive the documents related to today's hearing?
Yes, I did.
Okay. Mr. Salazar, I'm not sure if you're in a position to, now that document that you have there, has it been filed or is it just still in the electronic format? Has it been filed with the court?
No,
Okay,
no, sorry. It's just been very unclear, the whole process with all
Sure.
this.
sure. Do you have access to a printer?
I don't, but I could run to the local store nearby to print it.
Okay.
what I had
Maybe
to do
maybe
last
that's something that we could do, because my intent today was because we didn't have a declaration of service in place that the case would be set over. I recognize it sounds like you're probably traveling from Puyallup.
4 hours away.
Right. So maybe what we could do is we could pause on this and Mr. Salazar could print out that document and come back later on the docket and we can address the issues that have been presented.
And that's all you need is the proof of service.
Yeah, the declaration of service.
Okay, that's it.
And does it say on that, what you're looking at there on your phone, does it say that who is the person that served Ms. Salazar?
Yeah.
Who was the person?
So his name was Norman S. Transeth Jr. It was through like a private investigator
Okay.
firm.
Okay.
Yeah.
All right. So Ms. Salazar, any concerns if we were to proceed in that fashion today? Just grant a little bit of time for the printing of that document and I could take a look at it and then we could move forward today.
That's okay with me. I also gave Jordan my response paperwork and I have my proof of personal service with me and I haven't gave it to the clerk's office. Is that something I also need to do or?
So the documents that you served upon Mr. Salazar, the service or the proof that
Is
you're
it
serving with that, you haven't yet filed that, correct?
No, I have it with me. I haven't filed that. I just gave him my response on the day that it was given to him.
Okay. Mr. Salazar, did you get a copy of that?
I have it, yeah.
Okay.
And if you want, she can email it to me. I can print them both out.
Ms. Salazar?
That would be fine.
Okay. Yeah, why don't you do that? You could send that off to Mr. Salazar. Mr. Salazar can make those, print those documents up, then come back.
Actually, I'm sorry, because she gave me her response. I have it.
Hmm.
Will that be fine? Her response to it?
The declaration of service is still needed.
Okay.
So that's what Ms. Salazar proposed to send to you via an email that you could also print.
Yeah, she gave me her actual response.
Right, but we still need that declaration of service.
Oh, okay. I
Yeah,
got it.
yeah.
Gotcha.
So why don't we do that? Why don't we just, we'll
Constance
pause on
Sonoda
this
line?
case and then we'll call it in just a little bit. Okay, thanks.
I'm here, Constance Sonoda.
Great, welcome to you, Ms. Sonoda. And Mark Thomas, are you on the line today? Mark Thomas, if you're on the line, I'm not able to hear you, so make sure you're unmuted and state your name. Mark Thomas. All right, not hearing a response from Mr. Thomas. Ms. Sonoda, this is your, I believe this is your motion for adequate cause and a petition to modify the parenting plan.
Correct.
It looks like there was service on Mr. Thomas, and that was effectuated on June 24th. So with June, when you count the days, there's kind of a certain time frame that needs to occur between the time of service and the time of hearing. So if you count the days between June 24th until today's date, which is the 3rd, we have 1, 2, 3, 4, 5, 6, 7, 8, 9, which is inadequate time for a response. So there's a local rule number 88 that you may or may not have looked at.
So it got delayed because I was waiting for child support. They told me that the address that I had for him was incorrect and that I had to fill out this paperwork and have it approved to get his last known address. And once they finally gave it to me, it was indeed the one that I had, but I wasn't able to get him served until last week. But she did hand it to him.
Right. Yeah, I saw the service declaration there and indicating that he was served, but the timeframes are too short.
Okay.
And so we're not able to hear the matter today just because of the timeframes haven't been met. So probably the best approach to this would be set it over 1 to 2 weeks, just to make sure we meet those timeframes, and then come back on that date. So today being the 3rd, let's see, let's count that 1, 2, 3, 4, 5. We'd be looking at July 17th, Wednesday, July 17th. How does that work for your schedule, Ms. Sonoda?
I will make it work for my schedule, but does that mean I have to have him served again?
No, you don't have to serve him those documents again. You've already served those documents to him. So what
Put it on mute, or so they can't hear me.
Oh, Mr. Guajardo, we can hear you
Yeah.
loud and clear.
No,
So I'll mute you. So Mr. Sonoda, you do not need to send all those documents to him again. That's already been accomplished. What you do need to do is just send a docket notice to him. Basically, if it's a hearing notice to say that on July 17th at 9 a.m. that there's going to be a hearing related to your motion. And if you look on there's a form page, or you can check with the clerk's office. It's either a 1 or 2 page document that's called a docket notice.
Yeah.
Easily obtainable, and then if you could just mail that off to him.
Okay, just mail it to him and that's fine.
Yep.
Okay.
And then
Thank you, Your Honor.
And then make sure you file that docket notice after you've completed those tasks.
Okay, so I need to come into the clerk's office and just file it again to get on the docket, or am I already on the docket because you're moving me?
You're on the docket, but he needs to receive notice.
Okay. So
Sure.
I need to send it I need to send one of the, basically the service papers. I file it with the court.
Yeah, the hearing notice says, hey, on such and such a date, we're going to have a hearing related to a motion to modify. It's going to occur on July 17th at 9 a.m. And then there's a second page where you would sign it. And then there's a place for the address that you sent it to him and then so that's basically the document.
Okay, thank you, Your Honor.
Mr. Great, we'll see you then. Feel free to take a seat.
Thank you.
And then Ms. Wonser, are you on the line?
I'm here.
Okay, Ms. Wonser's present. All right. So thanks for your patience. I appreciate you coming back this week. So we're here on Ms. Wonser's motion related to temporary orders, in particular the parenting plan and use of vehicles and payment of mortgage and other assorted items. So Ms. Wonser, if you want to go first and just lay out your position, why you feel that's correct and in the best interest of the children and equitable and fair, and then we'll hear from Mr. Sickles on the same issues.
Okay. Well, I just feel like everything's just been going so smoothly since I've moved out. Back in mid-January, I left the family home, and we've been following a 50-50 schedule the entire time. The boys have been doing really well.
Okay. And then you had made mention that it's your position as far as you want to keep the Dodge Journey. And then can you tell me about that? And then can you tell me about the mortgage?
Well, the Dodge has been the car that it's just been my car. I didn't have a car prior to having it. So that's what I drive. And I did purchase an older Jeep. It's an early 90s model, but it does not consistently run. So Devin was allowing me to continue using it. To which I might add, I have been trying to contact him recently. The registration expired and I can't get it registered, so I'm not able to drive it any longer. And they won't allow me to register it. It's not in my name.
Okay. And then as far as the mortgage?
I do believe he is paying the mortgage that
And
Devin is.
What's the amount of the mortgage, do you know?
The last time I was paying it, it consistently, it was 1668 a month, but I know that it did go up in February, I believe.
Okay. Any other information you want to share based on your motion?
No.
Okay.
That's everything. Thank
All right.
you.
All right, Mr. Sickles?
As far as the children go, I feel that they are better off at home with me. They are presently spending most of their time with her sister, not her. As far as the mortgage goes, it's 15 something, and yes, I am paying it. The Dodge is a vehicle that I got. It's under my name, and the loan is in my name. I have not been able to make those payments, to be completely honest with you.
What's the amount of the monthly payment?
251 something.
And do you know the insurance cost?
I have, it was 180 something. Right now, I'm not sure.
Okay. All right. And then tell me about as far as the request, there was Ms. Wonser had indicated that since the separation, the two of you had kind of come to an agreement, a temporary kind of agreement related to the children as far as the residential
agreement
time.
is what she's told me what is going to happen, and that's what's been happening. It wasn't an agreement, it was I was told.
Okay. Okay.
And I would like to also point out that she also owns a Kia Spectra, a Jeep, and an F-150.
Okay. Okay. Anything else?
I did have, I've had issues with her showing up at the house randomly. You know, once in the middle of the night when I was sleeping, she showed up yesterday. Sheriffs were involved. I did put in for a protection order this morning.
Okay. And was that through district court or through superior court?
Superior.
And do you know if it was this associated, is it the same cause number as this case, or were you given a separate cause number?
We didn't get one.
Okay. All right. Okay. Thanks. Ms. Wonser, anything in reply?
Well, he did mention the additional vehicles that he is fully aware are completely non-running. The Kia Spectra is a vehicle that I do own, that I've owned since 2008, and he drove it for many, many years straight into the ground. The engine is blown. It had to be towed to my sister's house. And the F-150 also does not run or even move. The tires don't spin because the brakes or something froze up on it, which happened when he was riding or even driving it. I don't know. And I did go up to the house yesterday to pick up our older son Bryson, and I did go in the house. And
Who was present at the home? Was Mr. Sickles present?
Mr. Sickles was not present.
Okay.
Which later, when I did speak with one of the responding officers, he explained that that would not have been a very appropriate choice for me to have made because I no longer live there. But I did go in, and I was there to get our older son. He wasn't in the house, so I was in there texting him, and I used the bathroom. While I was inside, Mr. Sickles arrived home, and he came home with his sister and his dad. And they accused me of breaking and entering and said that they had changed the code to the front door, and his sister called the police. And I'm not really sure. I think that maybe they had misunderstood or something. because as it turns out, they checked the code after the fact, and my code still does work. I definitely did not do something like that. And when the police were there, they did explain to them that I had not done anything wrong, and I wasn't refusing to leave or anything like that either. I wasn't arguing with anybody or anything. I don't know why they were acting like that. I think that they got upset. That's what the officer told me too. He said that maybe his sister was really upset because she thought I was trying to burgle the house. Those are the words he used. So
maybe bottom line, let me just double check with you. So here, it sounds like Mr. Sickles is making a request that in the parenting plan that both parties not go to the other party's home. Do you have any concerns if that language is included in a parenting plan?
I don't have any concerns about that.
Okay. All right. Thanks. Let me ask Mr. Sickles a different question related to the residential time. I noted in my notes here that you generally work Monday through Thursday, noon to 9 p.m. Is that accurate?
No.
Okay.
I generally work 7:30 to 4:30,
7:30
Sunday through Thursday.
Okay. All right. And is that a change in the schedule, or has it always been that way?
As soon as we separated, I made sure my job made it to where I have days off to spend with the kids.
Okay. So you're working days?
Yep.
Okay. All right. Thanks. Okay.
I would also like to point out that all of her vehicles were driven away from my house.
Okay. All right. Thanks. Okay. So as far as the parenting plan, I'm sensitive to what Mr. Sickles has indicated, that, when I said, hey, it looks like there's an agreement the way you've been doing this since January. And he said, well, basically I was told that this is the way it was going to be. And I recognize that there's relationship dynamics and the like, and then also that Xander is 12 years old, and he's been under this kind of arrangement with his parents for more than half a year, or roughly half a year. So I know that there's concerns on both sides related to that. However, at this point, I am going to, on a temporary basis, make it a 50-50 plan with basically a week on, week off, and the exchange will occur on Sundays at 3 p.m. As far as there was a request by Ms. Wonser for a mental health evaluation of Mr. Sickles, I'm going to deny that at this point in time. As far as any joint decision making, it'll be joint decision making as for non-emergent healthcare, education, extracurricular, sports, and the like. As far as the vehicles, it sounds like there's some dispute as to the vehicles. What we know is that there's the Dodge is the newer car, it sounds like, and the GTI is operable. There's some dispute as to the pickup truck and the Kia Spectra, and their drivability. So I think
Your Honor, if I might just right here at this section, I tried to speak to Mr. Sickles last night about the Dodge. I tried to ask him if he wanted it back. I'm not trying to dispute whether I would keep it. He can have it. He can take it back. I don't know. That was always part of the deal, is that he would. And if he is asking for it back, he can take it. Like I said, I can't drive it. He won't speak to me. I can't even get it registered. So I don't want to drive it anyway, because I don't want to get a ticket.
Okay. So you're indicating that as far as the Dodge, that he would use it and he would pay for it?
If that's what he wants, if he wants to take it back, he can have it. What I'm saying is that if that's what he wants, but he's not giving me an opportunity to speak to him about it at all. So
okay.
I'm not sure what he wants.
Okay. So that's your vantage point, is that if he wants to use it and pay for it, then he's more than free to do so.
Yes.
Okay. So with regard to the Dodge, if that's your position, my sense is that Mr. Sickles would like to have that vehicle back and do with it as he would. Any concerns if I award the Dodge to you along with the debt associated with it, if any?
Well, I'll be completely honest with you. I'm almost 3 months behind on those payments, and if I take it back, it's going back to the dealers, and I'll just suffer whatever consequences of having it go back.
Okay. So tell me what your position is. Do you want the car back, or do you want her to keep it?
I'll take it back.
Okay. All right. So the Dodge will go back to Mr. Sickles along with the debt associated. Well, it sounds like the debt hasn't transferred. He still has it. And then as far as the mortgage payment, it sounds like this is the mortgage on the home. I believe this is correct, Mr. Sickles. This is your childhood home. Sounds like that you
Yes.
bought from your parents. Okay.
Yes, sir.
All right. So as far as that, the mortgage payment, Mr. Sickles will continue to make payment of that. And just double checking, Ms. Wonser, where are you living?
I'm at my sister's.
That's right, out on Ocean Beach, correct?
Yes.
Okay. All right. So the mortgage will be assigned to Mr. Sickles. He'll remain in the home at least for the time being with this temporary order. And as far as I think it's proper that both parties stay away from the home of the other. So that'll be included within the order. And I'm also going to include just a communication order that just basically indicates that the parties can and should communicate, but only related to the child. So I think it's really important for parents to communicate when they have a child in common, and if there's no communication, then the child suffers as a result. So I'm just going to put a notation down here on that.
I am
Go ahead.
completely for that as long as it's just about the children.
That's court's order. All right. So let me just take a moment. I have a proposed parenting plan here that I'm going to amend just slightly.
Can I say something, Your Honor?
You can.
I was just wondering about a guardian at litem to proceed.
Sure. Ms. Wonser, do you have a position on the appointment of a guardian ad litem to investigate the case and report back?
I'm not sure financially I can afford one.
If there's concerns related to payment and a person is unable to pay for it, generally the county picks up the tab.
Oh, okay.
Other than that financial concern, do you have any concerns if the court were to appoint a guardian ad litem?
No.
Okay. And then is that what you want, Mr. Sickles?
Yes.
Okay. So the way we go about doing that is we have a rotating schedule of guardian ad litems or list. So then the next three individuals come up on the list, and then each party has the opportunity to strike one of those three names that if you don't feel comfortable with one of them. A lot of people have no idea who these people are, and so they don't strike anybody. They just kind of take the next person. So we can take care of that right now. So I'll ask the clerk to read off the names of the next three individuals. Please.
Heather Kale, Karen Lawrence, and Beth Fellows, Your Honor.
Okay, so I'll ask Mr. Sickles, any of those three that you'd like to strike?
Karen?
Karen Lawrence, okay.
Yes.
She's stricken. And Ms. Wonser, any of those remaining two you'd like to strike?
Beth.
Okay. So Heather Kell is appointed as a guardian ad litem. As far as finances, let me double check with Ms. Wonser. Ms. Wonser, what's your monthly net income?
Oh, 1,800,
Okay.
1,900.
Okay.
I'm not
Mr.
sure.
Sickles, what's your net? What's your rough net income per month?
24.
2,400. Okay. I'll make it a county pay for both parties. So what'll happen is that Ms. Kell will reach out to each of you, and she'll send out kind of what's called a welcome packet, if you will, and then you'll fill out that paperwork and get it back to her promptly. And then we'll need to, she will gather that information, then we'll have a review. Generally, it's about 90 days out is when we have her report submitted. So that would put us at the first week of October. So it'd be October 2nd. That's when I'll put down in the order when the October 2nd will be when the report is due. And then let me just finish up with this order. So one question on the exchange location. The exchange location generally has been at parents' home, the respective homes of each other. And generally that works out best for children, kind of a safe place for them to be and to be picked up. Any concerns if we keep it there and just have the restriction of, not entering into the home of the other?
I am fine with that. And most of the time when the kids are getting dropped off at my house, it's her sister or brother-in-law bringing them. So that works for me.
Okay, Ms. Wonser?
Yes, that will work. Yes.
Okay, so I'll just put an indication not enter into the home, but the exchanges can occur at the respective homes. So it's generally the picking up parent is the one that'll be doing the retrieval. So when it's your time to start, you'll go to the other person's home, pick up the child, and go from there.
Okay.
Okay, so the pickup point on Sunday at 3 would have to be after 4:30 because I don't get off work till 4:30 on or 5 on Sunday, sorry.
Okay. Ms. Wonser, any comment on that?
I'm sure that we'll just continue to make it work like we have done so this whole time.
Okay.
I'm
So
not concerned with any of this because there's been zero issue with the children with pickup drop off, nothing at all, nothing.
Okay.
We've been 100% great with the kids.
Okay. So we'll make it 5 p.m. the exchange time on Sundays.
Okay. And for me to get the Dodge, am I just supposed to go there and get it or?
Do you have any proposals, Ms. Wonser?
I would like maybe just 1 week to clean it out.
Works for me.
Okay, so if we look at a week from today, so that would be on the 11th. That's a Tuesday. Do you want to set a time and just say on the 11th of July at 5 p.m. the exchange will occur?
Okay.
Okay, July 11th, and that would be I would assume at Ms. Wonser's home.
Or if it's easier for him, he could arrange when he does the pickup for the boys on Sunday, he could get the car on Sunday.
Okay,
And I could have it ready then.
on the 9th.
Yes.
That's probably easier. Just go
Only one trip. Yeah.
July 9th at 5. Would that work to exchange your child?
If I can find somebody to drive me there to get the car, yeah, I guess.
Okay, well,
Sorry.
let's set it for that. If the parties agree to something different, that's okay. But if you can't agree, then it'll be on July 9th, Sunday at 5 p.m. for the exchange of the Dodge. One last question on the parenting plan. There's a designation of a custodian. Ms. Wonser had proposed that there be an altering of who's designated as custodian from year to year. Again, this is a temporary plan. There'll be a final plan, but on a temporary basis, does either party have any concerns if there would be kind of that rotating designation of custodian? Mr. Sickles?
No.
Okay, Ms. Wonser, you propose
No.
that. I assume you're okay with that. Okay.
Yeah, I'm okay with that.
All right. Okay, so I've signed off on the temporary parenting plan. The parties can get a copy of that for your records. I'll need to fill out an additional order here. I'm not sure if I can do that now, if it'll take too much time. Let me just take a quick look. Okay, thanks for your patience. So with the temporary family law order, it's a summary and it also provides some direction to the parties. It indicates that there's a parenting plan that has been ordered, which I've signed. There's no request at this point in time for child support. So I note that. As far as the family home, I indicate that Mr. Sickles would remain in the home and he's responsible for the associated debt of the home. And as far as the Dodge, the exchange of the vehicle will occur on the July 9th, as we mentioned, and that Mr. Sickles will be responsible for the associated debt on the Dodge, and that Ms. Wonser would continue to use the the Volkswagen GTI, Mr. Sickles would continue to use that, and then the other vehicles that have been mentioned, those will just stay with Ms. Wonser. There's also an indication the mortgage will continue to be paid by Mr. Sickles. The vehicle, it just specifies that the Dodge debt will go to Mr. Sickles or continue to be with him. And that insurance on the car will be the responsibility of Mr. Sickles. And it sounds like he may be getting rid of the car here soon. So that would go away if that happens. And there's, as far as a restraint, just both parties are prohibited from entering the residence of the other. So that's that. I think that comports with everything that we talked about here today. I'll be filing a separate guardian ad litem order appointing her, Ms. Kell, and then just look for her to the information you get from her, and then just promptly respond and be in communication with her.
Okay, and Your Honor, if I may ask one question.
Yeah, go ahead, Ms. Wonser.
Um, I know Mr. Sickles mentioned something about the insurance earlier, and I was wondering if the Jeep is still insured or not.
If the Jeep is insured?
Yes.
If you know, Mr. Sickles?
It is not.
Okay, he's indicated that it is not.
Okay, thank you.
Okay, so any other questions or concerns at this point, Mr. Sickles?
No, sir.
Okay, Ms. Wonser?
No.
Okay, if any party needs to get a copy of any of the orders that have been signed and submitted today, you can check with the clerk's office and get copies.
Okay, thank you.
All right, that'll
Thank
conclude
you.
today's hearing. Thank you for coming up and
Thank
taking
you.
a seat, and I'll just double check with Ms. Salazar that you're still there. Yep, I can see you.
I'm here.
All right. Let me touch base with Mr. Salazar. Were you able to print out those documents, your declaration of service and also the service document from Ms. Salazar? Okay. I'm just taking a quick look at those documents. So I see a proof of personal service where Ms. Salazar, you had an individual serve him your response. So I see that. And then I see Mr. Transith served Ms. Salazar on June 11th, regarding a petition for modification of the parenting plan, proposed parenting plan, declarations of public assistance, family law calendar notice, summons, petition, order data clause. Okay. All right, thank you. I appreciate that. So those documents will both be filed. So don't worry about filing them. They'll be filed today. So this is your motion, Mr. Salazar, related to the modification. So I'll hear from you first, please, and then I'll hear from Ms. Salazar.
Sure. Yeah, so I was active duty Coast Guard. I came from Alaska and I was stationed in Seattle to be closer to my son, Carly, and my son Jackson. They moved down to Kelso with her family. So once I was stationed in Seattle, I was maybe three hours away. So I wasn't close enough to have 50-50 custody of Jackson, especially when he started school. Now that I'm out of the Coast Guard, I'm in the reserves now. My wife and I, we just got married actually this past Saturday. So I'm remarried. We're buying a house. Our house closes on the 18th of this month in Toledo, Washington. So we're just trying to make all the efforts we can to get closer to Jackson, to have him 50-50, and just to be more, in his life consistently.
What's the travel time from Toledo to, say, here, the courthouse?
From Toledo, where we live, it's only, I think it was 25 miles.
25 miles. And what's the travel time?
Like 26 minutes.
Okay.
26, 27 minutes.
And Jackson's 7?
He's 7.
7 years old. Okay. All right. And your request is, you're requesting basically a split schedule, 50-50 residential schedule.
Correct. Yes.
Okay. And the proposed timeframe of the exchange, remind me of that?
Yeah, so I think I messed up on the paperwork. I accidentally put every week, but I meant to put every other week. So I would have Jackson 1 week, Carly would have him 1 week. That was just what I put, just for like a 1 week split,
Right.
but we could always kind of modify it to like 5 days, I was just trying to keep it kind of even. Right now, I only have him on the weekends. With my new job, I work on the weekends a lot. So it's just, I don't get to see him much if I have him only on the weekends. So that's why I was trying to just kind of keep it at 1 week increments. I think I put on there Monday
Monday at
drop
5.
off time. Yeah, just after school, just to kind of make it easy.
Okay, Monday at 5. And tell me why you feel that's in Jackson's best interest.
Just to have his father in his life more consistently. I haven't been able to be there just because I've been active duty military. So having that good, stable relationship with his father, his stepmom, my family, when they're able to visit, they're in Idaho. So they come try to visit as much as they can.
Okay, all right. All right. And then as far as there was some question about the school.
Yeah.
Could you address that issue?
Yeah, so right now Jackson's at Butler Acres here in Kelso. Carly was talking about moving him to Rose Valley. That's closer to where she lives, out in Rose Valley Elementary. Because we're moving to Toledo, the kind of halfway point is Castle Rock Elementary, which is where he plays the majority of all of his sports through Kelso Recreation. So I was asking Carly if we can move Jackson to Castle Rock Elementary, since that's kind of the halfway mark. It's only, I want to say 20 21 miles from me, and I think it's like 25 miles from her. So it's kind of like that 50 split as far as distance goes.
And that's based on assumption that there would be, the schools would allow for kind of a boundary waiver
Right, yes. Yeah,
Okay.
the out of district
out
request.
of district, right?
Mhm.
And then school at Castle Rock, what time does it start?
I'm not sure on what time the school starts.
Okay, because he'll still be in elementary.
Correct, yeah,
Okay,
so we'll be
for
going to
years.
second grade
Okay.
this upcoming fall.
Okay.
Mhm.
All right. Okay. Any additional information you want to share about your request?
No, Your Honor.
Okay. All right. Thank you. Ms. Salazar, I'll hear from you, please.
So Jackson has been in my care since he was.
Well, let's see, Ms. Salazar, the audio was pretty soft, so I missed the first part of what you had spoken.
I'm sorry. Yeah, Jackson has been in my care since he was a year and a half. I haven't moved out of Rose Valley. I've been in Rose Valley since we got here. So he's 7 now, so he's been in my care for 6 years, pretty much, just doing our regular every other weekend schedule. Jordan lives so far away, he wasn't able to do the Wednesday visitation because it was kind of obviously a whole day trip when you're coming from that far away.
Could I ask you a question?
Sure.
There is a representation that Jackson's going to Butler Acres Elementary. Is that accurate?
Yes, that's accurate. So the reason why I did that is Jackson was in preschool at Rose Valley. He originally started there, but I didn't feel with the way that he learns, he wasn't doing too well. So I had the opportunity to put him in transitional kindergarten, which isn't available out here. So we'll
see if the thaw comes here in a bit. She unfreezes. Ms. Salazar, if you can hear me.
in first grade.
Oh, I apologize, Ms. Salazar. You froze there for a bit. So you were telling us that you just finished telling us about the transition school or transitional kindergarten, and then it kind of froze, and so I missed what you had said.
Yeah, so I drove every day through transitional kindergarten and through first grade to Butler Acres, which is about 30 minutes away from where I've lived for the last 6 years. In the Valley, I have moved to different addresses, but I have been within a mile range because my whole family lives out here. My parents just recently gave me their home, and they are building a tiny home on the property for them to live in. We are on acreage, so this is pretty much very just well established for him. The only reason I'm moving him to Rose Valley is because now that he went through first grade, when we drove every single day into town, they didn't have a bus system because he was a choices kid and I had to get him into that school. I feel like he's ready now and he is all caught up and he is actually able to take a bus to school. And it's only 8 minutes away from my house as opposed to me driving into town every single day like I did the year before. I feel like he's ready now, and the school was just recently remodeled. So the kids were split up between Barnes and Catlin, I think. They were split up. So all the kids are sort of new to Rose Valley. They'll all be meeting each other for the first time. So Jackson, he's just established in his sports here, his friends here, our neighbors here. And I didn't feel it would be, to drive him every single day, being far away from both parents to a school in a new district in hopes that he could even get into something new like that. This has been his home. And so that's kind of the school situation right now. So I do want him to go to Rose Valley because I feel like he's ready now and he is caught up, and Butler Acres did that for him. So that was the only reason he ended up going there.
Okay. Thanks for that explanation. What is your position regarding the request for a 50-50 plan versus what it is now?
I am willing to do more time. I want him to be with his dad. I want him to see his dad, but I don't think it's in his best interest I've done the driving every day, and Castle Rock is even further than that. to get him to school on time, be there at 8 a.m. every morning. It is a lot. And I don't feel comfortable with him being that far away in a district away from both parents. I'm willing to do more weekends if he wants more weekends, more visitation, anything like that, even days during the week if he wants to stay at his dad's, and Jordan would be willing to drive him to school as I did, for a couple years. I think that would all be fine, but I don't want to take him out of everything that he knows right now.
You mentioned earlier that the trip from, I guess, Rose Valley to Butler Acres was it a round trip 30 minutes or one way 30 minutes?
No, about like 25 minutes or so from my house to town. Yeah.
Okay. And then the distance from your home to, say, Castle Rock, what's the time there?
Can I look it up really quick? Just the
Sure.
distance. Okay. I'm not sure.
You could look it
I
up.
already looked it up. It's 27 minutes.
Okay.
From my address.
Yeah.
From one.
It says 33 minutes on I-5.
Okay. Thanks for checking that.
Yeah.
Okay. Other information you want to share about the motion?
Jackson does have a little sister. He has a 2-year-old sister that he has been with, and they are very close. I also don't want him to be separated from that for extended periods of time. But as far as that goes, I think that's everything.
Okay. All right. Thank you. What I wanted to follow-up question with Mr. Salazar regarding, you indicated that you work a lot of weekends. Is that correct?
Yes,
So
sir.
does that mean Friday, Saturday, Sunday? Is that the?
It's mainly Fridays and Saturdays,
Right.
some Sundays. I just recently started my own business.
Okay.
So it's based off of when I get booked, but most of my gigs are usually Fridays and Saturdays.
Okay.
Mhm.
Okay. Okay. All right. So I'll just give the parties just anything that you may have missed in your initial presentations. If you want to share that, I'd be open to hearing from you, Mr. Salazar, and then Ms. Salazar.
Sure. Yeah, one thing I thought of was since I was stationed in Seattle, one thing Carly didn't really mention, she's came up to Seattle to drop Jackson off to me maybe twice within the past 3 years. I've came down to Kelso for all of Jackson's games throughout all the sports the past 2 years. So there's been multiple weekends where I've spent about 6-7 hours in the car round trip. And it was on the weekends where I didn't even have Jackson. It was just so I didn't miss his games. When it was, so right now with our parenting plan, I pick up Jackson Friday, drop off Sunday. Most of Jackson's games are Saturday mornings. So for me to meet Carly on Friday, drive back home, then drive all the way down here Saturday morning, then turn around, drive back. We've done that multiple times. So there's other weekends where we've spent 10+ hours in the car, just to transport Jackson for where he's at now. Even with his football league, they were playing down in I forget what the name of the town was, but it's like another 40 minutes south of here. So it was just like a 12-hour weekend, a couple weekends during football. It's just been a lot. But I've been doing everything I can to be in Jackson's life and to be supportive and get him out there. We don't want to move down to Toledo. We have business, we have friends, we have everything established more up north. But we found this property in Toledo. It's 3 acres. My wife has horses. It's just a nice home out in the countryside that's going to be great for Jackson, neighbors, kids around. So we're making this huge shift in our lives with all the stability we have to be closer and be more established for Jax. So that's the whole reason of us moving down to Toledo.
Thank you.
That's it. No.
Ms. Salazar, any other comments from you?
I think that more time with his dad would be great. I just disagree with the 50-50 plan and putting him in a school that is far away from both of us and in a different district. I would like to make something work, but I don't think that's what's best for him right now. He's been here for so long. I also have made the trips, you know, as far as sports and everything, and making sure that he is on time with everything and signing him up and paying for it. And I just feel he's very well established. More time with his dad is great. I just don't think this is the best way to go about it.
Okay, thank you. All right, give me just one moment, please. All right, thanks for your patience. So regarding the motion for a finding of adequate cause, I'll make that finding that there is adequate cause to change the parenting plan that's currently in existence. The basis of that is the fact that Mr. Salazar, his duty station, well, he's no longer in active duty, so he's able to move more in closer geographic proximity to the couple's son. So I'll make that finding of adequate cause. Secondly, and maybe I think, well, obviously more importantly, I think Jackson has two very committed parents that are putting his needs the best they can in first position. He's been well taken care of by both, and so I think his future is bright. He's got two parents that are really love him and are doing their best to put him in first order priority. So the proposal here is for a 50-50 split. Mr. Salazar points to that being beneficial for him, and Ms. Salazar has concerns related to, you know, has lived in the Rose Valley area for most of all of his life, and he has friends there. There's a new school there that's been redone, and he's had an opportunity to kind of come together with a new group of kids that are all coming there from other schools. Mr. Salazar indicates that that Castle Rock elementary school is a possibility, and that was kind of a halfway point, and that would allow both parties to roughly, if I were to adopt that 50-50 plan, would require each party to drive roughly 30 minutes, depending on traffic, to drop off and pick up Jackson. So my sense here is that on a temporary basis, I'm going to grant the 50-50 parenting plan with exchanges occurring on Monday at 5. It's conditional approval of that. And when I say, and the reason I say that is that I don't know what Castle Rock's going to do. Castle Rock may say, yeah, that's great. We hereby grant the boundary exception and come on in and be with us. Castle Rock may choose not to accept that. So I don't know what they're going to do, but if they approve it, then I'm fine with it. So if it happens to be that they don't approve it, then we'd need to come back to court to figure out next steps. But on that condition of them approving, then I'll approve the 50-50 plan. I think that I recognize it places extra burden on both parents. It really does, as far as like the time spent in a car driving, and that also impacts Jackson. However, there's been a pattern of him driving a period of 20, 30 minutes on a regular basis. So there's not going to be a tremendous amount of change there either. I am sensitive to the fact that moving to a different school, if allowed, changes up the friend group. It sounds like the friend group is going to be changed up, whether he's at Castle Rock or at Rose Valley Elementary. So a similar situation that he would be in. Not exact, obviously, but similar. So with that, the proposed parenting plans that were filed by the parties, just take a quick look at one other item here. All right, so let me just ask, Ms. Salazar, you received a copy of Mr. Salazar's proposed parenting plan. When you looked at that, did you see any glaring concerns or things that you had concerns about?
No, there were no concerns with the parenting plan. I was just proposing more weekends and more time in the summer is all I was asking, instead of changing up his schooling.
Right. Okay. So as I indicated before, it's a temporary plan. So that means that it's not yet finalized. There could be still a trial on this issue. So it's a temporary plan, and like I said, it's conditioned upon Castle Rock accepting the boundary exception, allowing Jackson to attend there. So what I'll do, I'll adopt the parenting plan as submitted by Mr. Salazar, and then I'll sign off on that. Let me just jot myself a note here. So other than that, let me just double check with the parties if you have any questions, Mr. Salazar.
Yeah, so how does the child support work with that? Because I think we had something already scheduled for the end of this month.
That's when it's scheduled for.
Okay.
Yeah. So the issue of child support, that's scheduled for later, and then we'll address that issue at that point in time.
Okay.
So, and it'll be addressed in the context of the assumption that Castle Rock is going to allow the boundary exception.
I did have
Your
a
Honor.
question. Could we, if Castle Rock doesn't accept it, is there anything we could do now to, if Castle Rock doesn't accept it, could Jackson stay in Butler Acres
Certainly, I mean, that could be something that could be addressed at a future hearing.
for future hearing? Okay.
Yeah. Ms. Looney, I heard you speak up.
Yes, Your Honor, I believe what Mr. Salazar is referencing about child support is he had requested the state look into doing an adjustment of his support. But at this point, now that he has filed his own motion and is looking at doing a change to the parenting plan, our motion would no longer be valid. We would be actually dismissing that. So he would need to be taking care of that on his own.
Thank you, Ms. Looney. So the child support hearing that's scheduled for later this month, according to Ms. Looney, who brought the motion, they would be withdrawing that motion. So that would put the responsibility on one of the parties. If either of you are interested in modifying the child support, then you'd have to bring a separate motion and get that paperwork submitted. Okay. Ms. Salazar, did you have any questions?
So this order, usually our summers are like he gets 3 weeks of uninterrupted time in the summer. That's our original plan. So that does our summer plan still apply? And then this would be for the week to week would be for school. Is that correct?
Do you have any input on that, Mr. Salazar?
So the 50-50, I wanted 50-50 the whole time, all year.
Starting now?
Yes, but I say that as we're going to North Carolina tomorrow for my wife's grandma's funeral, celebration of life. We don't get back until the 14th of July. So possibly we could start on the 15th of July, Monday the 15th.
So under the current parenting plan, as pointed out by Ms. Salazar, it sounds like there's each party has an opportunity to have 3 uninterrupted weeks of vacation time or continual time with the child. Are you? Do you want to see that continue during the summer or no?
We could. I mean, we've been really flexible with each other. We work out whenever we have trips or family plans or whatever. We always work that out. So are you asking with the 50-50 full time in addition to 3 weeks in the summer for both of us?
Yeah, and it becomes difficult because school starts first week of September-ish, and so we're looking at there's only like 8 weeks remaining. So I'm just curious if maybe there would be the options are basically to do a 50-50 at this point and let the parties work that out as far as their your schedules and vacation time, or maybe a reduction, maybe make it down to 2 weeks uninterrupted vacation time for the summer of 2024, and then just allow the future to be reserved for a future hearing.
Honestly, Your Honor, to make it easy, I would just do 50-50, just 1 week at a time. And then if Carly has something that comes up, I always work it out with her. But if I have something, she always works it out with me. We're pretty flexible. Okay. If we have trips that are longer than 1 week.
Ms. Salazar?
If there is a plan, I would just like to go by the plan and we do work it out. But I've always agreed to more time. Like if Jordan needed if he had a job or something on a weekend, then he'd be like, can I double up weekends? And I would say yes. And I've been very open to doing that. But I would just like to stick to a plan now that I'm working. It's also going to affect my schedule too.
Do you have any thoughts regarding if it were to be for at least just for the summer of 2024, up to 2 weeks uninterrupted and do the 50-50 plan, but allow for that exception. And I'm not saying that it has to be that way, it's just want to get your input.
During the summertime, it's hard to say because we do plan like camping trips with Jackson and take him out and do things with him. So like right now we have a couple camping trips planned and Jordan's already had a week with him. So I would prefer that we just kind of schedule around the summer based off of what we have going on, if possible, and not do every other week.
Okay. All right. All right. Thank you. So the sense I get from the parties and just listening to the both of you is that there's some built-in flexibility that both of you extend to the other as far as parenting time or residential time. I think for this summer plan, the court sets kind of a baseline of what the residential time would be. And then of course the parties can agree to amend that or do something different, for vacations and the like. So I think what we'll do, we'll just make the 50-50 plan, and that the parties can then work around the plans that you have for summer plans. If it comes to loggerheads, the parties could certainly get in on a docket, and the court could make a decision if you're unable to kind of overcome some of those issues. So at this point, as far as the summer plan, it'll just be the week on, week off, and then the parties can show some flexibility over the summer and make things work for plans that you may have. And I think Ms. Salazar kind of raises a good point. That it sounds like Mr. Salazar's maybe already had a week of vacation. So the idea is that there's to be kind of equity or equitable time for each parent with their child. Okay. So any other questions regarding that parenting plan?
So the 50-50 order is this just based off of if he gets into Castle Rock?
Yep. Yes. Yes. And so if that happens, then the temporary order would continue. But however, if it's denied or not accepted, then the parties would have to note it up, come back to court, and then we'd have to take a second look to see what to do.
Okay.
All right. So I'll draft that. I'll get that parenting plan signed and submitted, and then the parties can get a copy from the clerks. Anything further?
And when would that start?
Yeah, good question. Ms. Salazar, do you have a proposed time frame in which that 50-50 would start with the exchange being on a Monday? I'm kind of just looking at maybe middle of July, July 15th, and I don't know if that conflicts with the Carolina trip. So, Ms. Salazar, do you have a suggestion?
Wouldn't that be after they had moved into the home, into the new address, or because they still haven't moved?
Right. I think with the summer schedule, it's probably going to be more greater flexibility as far as drive time and the like, and so I'm fine with it's starting now as opposed to the school year. So we're looking at a potential start date.
I would say maybe after July 20th.
Okay. Mr. Salazar?
Yeah, that's fine.
Okay, we'll have it start on July 22nd, and that's a Monday. Okay, so we'll get those drafted and submitted. That'll conclude things for now. So if there's any last questions, I'd be happy to answer those. Otherwise, we'll conclude the hearing. Mr. Salazar.
How soon would we be able to get copies from the clerk's office?
Pretty quick. I'll have to draft the parenting plan because there's a few amendments to it. And my afternoon is full, my evening is full. So usually I say by Friday afternoon, I would have that completed, and it gets to the clerk's office. So that would probably be Tuesday, Wednesday next week.
Okay.
Ms. Salazar, any final questions?
No.
Okay. All right. Thank you both. That'll conclude the hearing. Serafan, are you on the line?
Yes, Your Honor.
Okay. Welcome to you. And you're being represented by Mr. Ball, correct?
Yes, Your Honor.
Great. I see Mr. Ball's there. Can you hear me, Mr. Ball?
Yes, good morning.
Good morning. And Ms. Turnbull, guardian ad litem, I think I see you on the picture.
Yes, Your Honor, I am here.
All right.
Although, Your Honor, my understanding based on the order appointing is that I was to be discharged at the final signing of the final parenting plan, which has been signed. So I'm not sure if you want me to continue or not.
Yeah, I don't have any strong feelings at this point. I just noted that you're still involved in the case and wanted to make sure you're recognized, acknowledged.
Thank you.
Yeah, and then Ms. Kimberly Carroll, are you on the line?
I am, Your Honor.
Okay, great, thanks. First off, maybe we could address Ms. Turnbull's indication where she's basically seeking to withdraw from the case. Mr. Ball, do you have any input on that? And then Ms. Carroll.
I'm fine if she wants to withdraw at this time.
Great. Ms. Carroll?
Okay. If there's any input that she could give you regarding our case or recommendations at this point, it would be awesome. But I do understand that she's done her job, so I don't have anything else.
Okay, thanks. All right. Yeah, I tend to agree. It looks like Ms. Turnbull has provided her feedback and done the investigation, so I'm fine with her being exited from the case. So, Ms. Turnbull, do you generally prepare something that says something to that effect, or is that just a notation in the court file?
If it's been in the order appointing, I don't typically, but I will if you prefer.
Yeah, if the order appointing, if it indicates that upon completion and submission of your final report, then you're thereby discharged, then we can just abide by that and just let it be.
Okay, sounds
Great.
good. Thank you, Your Honor.
All right, thank you very much. All right, this is Ms. Carroll. This is your motion regarding contempt. So I'll hear from you, and then I'll hear from Mr. Ball.
Okay, yeah, so I filed this because in our parenting plan, it had requested that Eddie do several different things and then turn in monthly reports of what he's been doing. And in the meantime, I haven't received anything. And so by our parenting plan, it stated that if he hadn't done monthly reporting, that visitations would cease, and it's supervised visitations. And so I was advised through Amy to go ahead and follow the parenting plan and have the visitations cease at that point. So that's what I did. And then I haven't had a chance to file a revised parenting plan or any other proposals for what I would like to see happen possibly.
Okay. So let me ask you, if I may, Ms. Carroll, you indicated that the parenting plan says if those things aren't happening, then visitation ceases. Has visitation continued, or has it ended at this point?
So it ended. The supervised visits that he had set up through a third party ceased. His visitations with the kids has never ceased. He's been able to see them whenever he wants. And we both worked together to where he's come over multiple times and seen his kids. And so he's been able to see his kids this whole time. It's just the supervised visits without myself, his daughter, or my husband supervising is what just started. And so those has ceased.
So the unsupervised have ceased? Yeah. A little confused.
Sorry, the 2 hours twice a week with the third party supervisor that he was paying for have ceased. And then him coming over to see the kids anytime he wanted has ceased, since the guardian ad litem recommended I stick to the parenting plan that he needs to do all of what you ordered last time in March.
So there's no visits at this time?
None.
Okay, so the visits have ceased?
Yes.
Okay. And when did that end?
Let's see, June 3rd.
Okay.
Was the last time you saw them.
Okay. All right. Thank you, Ms. Carroll. Mr. Ball?
Oh, thank you, Your Honor. So it's my understanding that my client hasn't had parenting time since, I guess, the adequate cause order was entered in August 2023. So he had one visit on June 3rd, following the court's order on March 20th. And then after that visit, it was terminated. So in the process, the court needs to find that Mr. Serafang committed a willful violation of the court order so prior to March 20th, he wasn't under an obligation to complete a substance abuse evaluation, complete the domestic violence impact on children class, or complete a domestic violence assessment. And so he was also setting up the supervised parenting time through a professional supervisor. So he started that process, and it took some time. As maybe you're aware that those things in family law cases are not always easy to come up with. So he was in the process of doing that. Since this motion was filed, he's completed 2 of the 3 things. He completed the domestic violence impact on children class. He completed another substance abuse evaluation where there was no treatment recommendation, and he's in the process and has made an appointment. And maybe he has an update on completing the domestic violence assessment evaluation. So he's definitely not in contempt of the court order. It's a little concerning. And reviewing the case file, it's a little. I have, I guess, some confusion, and I didn't go back and review the last court hearing in March, but it appears that he was just served it doesn't seem that there was ever a full hearing opportunity to Mr. Serafan or a trial on the merits of the petition to modify the parenting plan, but there was a final order entered. It appears that it should have been, again, I didn't review the hearing, but it appears it should be like a temporary order. In any case, it's a little troubling that the mother can just unilaterally reject or erase or cease the visitation if she believes that he didn't complete or is not completing the court order requirement. So there's been a large time where Mr. Serafan hasn't been able to see his children. He still disputes some of the allegations that led to that changed it from every other weekend and every Wednesday parenting plan that had been in place since, I think, 2021 to just professionally supervised. And so he really would like to have the opportunity to, at least reenact his parenting time with his children. I think he's able to have telephone contact with them, but is not able to have parenting time with them. And so I guess the one reason we're glad to be here today is to clarify that his parenting time should continue under the court order, but also to clarify like where we are procedurally. And I mean, and if you can't answer, that's fine. But if the court believes that he could simply file a motion for temporary family law orders, or does he need to file a new motion for adequate cause, having completed some of the requirements that the court ordered him to do? And so, since we've, in response to the motion for contempt, Mr. Serafan did submit, the records of completing these requirements. And still we're here today on this motion for contempt, I guess, and the request is to just cease his parenting plan. And, so we're requesting attorney fees and having to respond to that. I think it should have been noted up for a review of the parenting plan in any event, but I don't think there's really a good basis for a contempt motion considering the timeline and the procedural history of the case and Mr. Serafan's good faith effort to complete the court's requirements. So thank you, Your Honor.
Can I ask you a question, Mr. Ball? It looks like there was a documentation showing on June 2nd, there was a payment of $155 for a class that was to occur on June 22nd. Did that class happen? And did Mr. Serafan attend?
Yeah, I think we submitted the certificate. That was the certificate of completion we filed on June 26th for the impact on domestic violence on children class. And then
yep, I see it. Thank you.
Okay.
Yeah, I missed that. I apologize.
Then I think the other thing I want to add, he's taking the domestic violence assessment through the SAM case, DV evaluation. He's doing that. So he just hasn't got, I think he's done the evaluation and we're just waiting for the report.
When was the evaluation completed?
I don't, the report has, you have to ask Mr. Serafin. I don't, I'd have to look at my notes about that if you don't mind, but
Mr. Serafin,
it's like last week or something like that. It's recently.
Mr. Serafin, when did that domestic violence evaluation occur?
I believe it was Wednesday, 2 weeks ago, Wednesday, the 26th.
Okay. And then
26th of last month.
Do you know what, are there any results as of yet from the evaluation?
I have not. Well, Sam Case said he's going on vacation.
Okay.
Yes. So he got all my paperwork, filled out all the assessment, what I need to do, and paid my, assessment fee, and said, well, I'll be on vacation. And he said, it's going to take months to get back.
Okay. All right. Thanks. And then, okay, that answers my question. Thank you. Ms. Carroll, just a brief reply.
So as far as a lot of this hearing, it all started in 2021, and so we were doing the guardian ad litem with Amy, and based on all her recommendations, then you had done your orders, and for that, I was just looking at for the substance misuse and the domestic violence portion. I was concerned because they're not collateralized, and so I don't know if that is something that is looked at in the courts as important. And then as far as the initial 2021 parenting proposal, I had put in there for the anger management and parenting classes. And so I don't know, because it's been a 3-year battle to get this far. And so I've submitted a lot of documents just of how we have been parenting and how many times he has seen the children. And so by seeing this statement that he hasn't seen them since August of last year, it worries me about uncollateralized substance evals and domestic violence evals, because it looks to be not true. And so I don't know if these evals are going to do the court justice necessarily.
Mr. Ball, do you have any input related to collateral input on evaluations?
Well, I mean, I think that it doesn't say that there needs to be collateral input looking at the final order, the final parenting plan. Whether or not sometimes that's up to the evaluation, and from my experience, that kind of makes that's why it's harder in these family law cases to get these evaluations done, because some of the evaluators don't want to do the extra work, or it's more of a burden to get into this family law situation and talk to all these different parties. And then, but I think the evaluation also relied on this evaluation from 2022, which also didn't recommend any treatment for Mr. Serafin, and that was related to, I think that was ordered by the criminal court back in 2022. That was in November 22 that evaluation was done. So I mean, they probably looked at that. Mr. Serafin hasn't abused alcohol since 2022, or no, I think that incident might have been anyway. So it's been a while, and so he's managed, him and his girlfriend have managed that problem that was in their life for now, and he says that the only thing he does is he sometimes consumes marijuana to help him sleep at night, and he doesn't expose the children to that. He hasn't even had an opportunity to do that. But as far as the collateral input, like, I guess is the petitioner asking to provide collateral input, because she wouldn't have any information either.
Well, the GLL, the guardian ad litem, recommended it be collateral for the court hearings, so that it's not a one-sided evaluation, because anybody can say I'm not doing XYZ, and they don't have any backing from another side as well. So that's why generally the courts, under my impression, will take collateral evaluations versus just going in and being evaluated by one party only.
Okay. All right, thanks. All right, thanks for your input. I appreciate that. one preliminary issue that I wanted to raise or address that Mr. Ball addressed, the March 25th parenting plan is designated as a final order. And Mr. Ball indicates that that's irregular, which I tend to agree. When there's a change in a parenting plan and it's based on hearing and declarations, it's not a full-fledged trial with opportunity to cross-examine and the like. And so his request is maybe, I'm not exactly sure, but he maybe kind of wants to pull that back and maybe make it a temporary parenting plan, or some type of accommodation that there doesn't need to be a finding of adequate cause to modify it. Ms. Carroll, do you have any comments on that?
I just think I'm looking at a standpoint from my kids and what's best for them. And at this point, the statements that are made or presented, there's things that are not true. And so without, like, that was the whole point of having the guardian ad litem, like, look at the different circumstances and do the report of the different parenting styles and what is truly going on in the home, with the history of the domestic violence stemming from 1999 with his first marriage to our marriage to his current relationship. It's just a big concern. He's still in that relationship that has been very domestic violence back and forth. And to be honest, the kids, he says that he's only smoking marijuana at night, but the kids, 2 out of the 3 don't want to come home smelling like it, and they don't want to be around it. And my youngest asks why it smells and what is that thing Dad smokes. And I mean, honestly, I want as least amount of interruption in their daily lives with counseling that my youngest is still in, and tearing them back and forth and putting them in that environment is why I wanted the guardian ad litem involved. So it wasn't just me saying these things. I think that.
Do you mind if I just interrupt with maybe a more pointed question? That the parenting plan for March is designated as a final parenting plan. That's irregular. It probably shouldn't have been that way. So there's one or two approaches to correct that. One, we could amend it and make it a temporary parenting plan, which I think would be more appropriate, or we wouldn't change it and just leave it as a final parenting plan and then make an allowance that there doesn't need to be adequate cause to bring a motion to change that parenting plan. Do you have input on that?
Okay. I just thought it was a final parenting plan to where if he just continuously did not do what was expected from the courts, he just wouldn't get the 2 hours twice a week from the courts, and that he could see the kids whenever he wanted to see the kids with supervised, but not a specific amount or a specific time. Okay.
All right, thank you. I think what I'll do on that preliminary issue is that there's no need for an adequate cause finding to bring a motion. So that I think that corrects the irregularity of the temporary versus the final, because before a final parenting plan, it either has to be agreed or there has to be a trial, and there wasn't either of those. Then the next point is the collateralized evaluations. Mr. Ball is correct in the parenting plan from March. It does not indicate that there was to be any input from collateral contacts. I think collateral contacts are absolutely crucial to any type of evaluation, because a person can simply say what from their vantage point, how they're doing, and that may not be the clear and most full picture that comes with maybe historical information. And of course, historical information is dated. People change. They change their behavior. However, history is often gives some indication of what the future may bring. So any evaluations, it sounds like the DV evaluation was recently completed. I think the evaluations need to be collateralized. I think that there needs to be collateral input from the parties to have a more clear picture of what is or is not happening. So I recognize that puts Mr. Serafan in maybe a compromised position, that it's going to take additional time for that to happen. But I think having a collateralized input for the domestic violence and SUD is important to get a more clear and full picture. So I'll require that. As far as the motion for contempt that's brought by Ms. Carroll related to willful and knowing violation of the March 25, 2024 parenting order. So what we do know is that there weren't specific timeframes listed to obtain the evaluations. What we do know is that the SUD evaluation has been completed, and that the domestic violence evaluation has also been completed, but not any results or findings or conclusions and or recommendations. And then we also know that the domestic violence class was completed. And again, the parenting plan doesn't give a specific cutoff date for when that's to occur by. So I think there, without those specific cutoff dates, that I'll deny the motion for contempt as far as violations. There's progress being made. And so that brings us to the issue of the parenting plan, where the parenting plan indicates that Mr. Serafan, once he gets that substance use disorder and domestic violence evaluations completed, and if there's recommendations, then he's following them, then he can ask for additional time. Then it goes on to say, if he's not doing that, then the visitation shall cease. So I think at this point in time, where there's been a good faith showing of completing those 3 items, 4 items, that the visitation should be reinstated with this professional supervisor. And if there is agreement for a non-professional supervisor to happen, that has to be in writing, and that could be up to 2 times a week for 2 hours each, so that time frame is specifically reinstated. And so now with the domestic violence evaluation, that has to be collateralized. It's along with the SUD evaluation needs to be collateralized. I think those both need to be completed within 45 days. And I know that and that's not necessarily a hard date, but it gives 6 weeks, I think, is a reasonable amount of time to schedule something and have that completed. I recognize summer is a busy time. Evaluators take vacations, and that may take a little more time for that to happen. So that would be my guidance there. It's not a hard date, that 45 days, but I think that should be kind of the working goal. So with all that said, I'll ask the parties if there's anything that may have missed in the items that were raised today. I'll start with Mr. Ball, then Ms. Carroll.
Oh, thank you, Your Honor. So I guess I would just request, I think the big issue, the kind of thing that was standing out before the court was the DV, the domestic violence issues that were presented to the court when, the motion was filed in August 23. And so since he's already completed the substance abuse evaluation, and there's I think there's also a drug test in the record from August 23. Anyway, my question would be to just, now that he's doing the DV evaluation, to just and I'm asking for a little bit more clarity, that the DV evaluation requires some collateralization, and that the court just clarify what those collateral sources need to be, so we can just be clear about that. So that's the one question. And then going back to the need, the court said there was no need for adequate cause. So does that can we just file like a motion for temporary family law orders, or once these evaluations are completed, that Mr. just set it on for review of the parenting plan? Just
I think so. I think so. Once those evaluations are completed, the parenting plan says he may petition for additional parenting time.
Okay, and then at that point, I guess we reserve it, also have an option to reserve for a trial on that, and what I'm saying. So
yes, yeah, that should be included in the order also.
Okay, and then I'm a little concerned about this language still. So the thing is, just be clear that his parenting time shouldn't cease. I'm a little worried about that word, just cease, that without a review of the court, I guess. Especially, it's supervised parenting time. One of the children.
So what I indicated was that the 45-day period is going to be key. So that 45-day period is for the time for collateralized evaluations to be completed for both the SUD and the DV. And the collateral input needs to come from a bare minimum from Ms. Carroll. And if the evaluator deems that additional people up to and including the GAL and others, then that would be the evaluator's preference and prerogative.
Okay, thank you, Your Honor.
Thank you. Ms. Carroll, do you have any questions?
As far as the supervised visits with a professional, is there, if it doesn't work out for, kids on wrestling camps and going to Dunes camp, like these types of things that have already been scheduled for the kids. If I have already pre-planned a lot of their summer and I can't accommodate the 2 hours twice a week that the professional visitation allows, is that mean that I would be in contempt, or is that something that can be worked around?
Court orders, there's a recognition that court orders are dealing with people's lives and that they're active, they're dynamic, and there's a lot going on. So the idea is that there's the court orders to allow for those 2 times per week for up to two hours. Obviously, if there's a pre-programmed or paid for vacations, camps, what have you, those should occur. And then there should be potential working around those. And so there's kind of a real life aspect to this and just a reasonability to things.
Okay, because that was the first thing that that came up with us trying to schedule these professional ones, is that the kids have other sports or things they're doing. But
and sometimes those things need to have some flexibility also. The flexibility is not solely upon Mr. Serafan, it's flexibility is imposed upon everybody.
Right.
Bullshit.
Okay.
Some of the companies don't be flexible with parent plan and parent.
All right, so flexibility is a thing. I just needed to hear that because I was told that it absolutely has to happen because the court ordered it. And so I just I don't have an attorney to tell me yes or no, that's right. So.
Well, the fact of the matter is if a child is scheduled for a week-long camp and somebody schedules supervised visitation after the fact that that's been made, that seems unreasonable to me. The child has that time already scheduled. And so, that's why I say there needs to be some inherent flexibility and understanding and reasonability.
Okay, thank you.
So regarding the motion, I'll deny the motion for contempt. Regarding the other items that were raised by Mr. Ball related to temporary versus final, the adequate cause finding, still need to go to trial, and the collateralized SUD evaluation and DV evaluation. Is that something, Mr. Ball, since those items that you raised, that you'd be able to provide a proposed order?
Yes, I'll do that.
And as far as a proposed order, we could set it simply on this docket, and we'd look at 2 weeks from now, on July 17th. So Mr. Ball would provide a proposed order. He'd send that to Ms. Carroll for your review. If you feel that he's accurately captured what the court ordered, you could feel free to sign off on it, submit it to the court for signature. If you feel that he does not have that summary or the correct summary of the court's orders from today, then we'd be here on the 17th of July at 9 a.m. to express your disagreement.
My youngest has a counseling appointment that morning. Can we do the next Wednesday, the 24th?
I'm fine with that, Mr. Ball.
Yeah, I think so. Excuse me. I think so. I do have a trial scheduled that day, but I'm trying to move it. So
the other option would be we could set for a Friday morning at 8:45. We could look at the 19th of July, Friday at 8:45.
I have 3 other things with 2 judges that morning. So,
well, let's set it for the July 24th at 9.
Okay, and then I guess the caption in the order, is that going to be like amended or corrected final order, or can I change it to just temporary order? Or
Probably just temporary order.
Okay, thank you.
All right, any final questions, Ms. Carroll?
No, that was my question, is that I was under the impression it was a final parenting plan, and if he's just not going to do what is needed, then he would just have to continue to see them whenever it fit their needs. I mean, he would come over and see them whenever it would work, but I thought it was to cease in general because he hasn't shown good faith since 2021 in doing any of these evals that were requested initially.
So I'll just clarify that the parenting plan is in effect. It continues to be in effect. There's no change in that. I'm just allowing Mr. Ball and his client to come to court and to modify that without a specific finding of adequate cause, which is normally the course when you have a final parenting plan. As I indicated, that final parenting plan probably should not have been designated as a parenting plan. So we're making allowance to allow that adequate cause finding to be waived, so there can be a motion to adjust that. Also, because the final parenting plan was made without the benefit of a trial, that should not have been. Either the way you get to a final parenting plan is either people agree or that there's a trial. So
Right, okay.
neither of those things happened. So it needs to allow for, so temporary parenting plans have full force and effect of a final order. It just indicates that because it's not yet resolved through a trial or agreement, then there still needs to be a final resolution. So the parenting plan still has full force and effect.
Ms. Blitz is
We'll see
here
everybody on the
representing the
24th
mother.
of
I'm here
July. Thank you.
representing the
Thank you.
father. We're here on presentation. There's only one issue for the court to decide, and that's the exchange location on the parenting plan. My client was under the understanding that you had said that the exchanges would happen at the parties' homes. The mother's requesting that they happen at Robert Gray Elementary. When I reviewed the clerk's minutes, there is a note that the exchanges will happen at the parties' homes. And so we just need you to make a decision on that issue.
Thank you, Ms. Bliss.
And Your Honor, that is my understanding as well. In review of the clerk's minutes, Your Honor had indicated that the transportation would, Eric, the oldest child, would participate in the transportation. If in the event he wasn't attending visits, transportation would occur at each parent's home. Later, we spoke, given the fact that there is a DVPO currently in place, obviously we have to modify that so Mr. is not violating that DVPO. Your Honor essentially left it up to counsel. In the meantime, we have agreed that exchanges would occur at Robert Gray during the duration of the DVPO. It's my client's request that just simply continues. Obviously, we're referring to Your Honor at this point.
Thanks. Ms. Powers?
The DVPO expires next week. My client would request that they exchange at the parties' homes.
Anything else, Ms. Bliss?
I don't know if I have, not that it's a terribly important issue, but I don't know if I have Mr.'s new address since he has know that the difference currently between Robert Gray and my client's home is a third of a mile, so a 6-minute walk or a 1-minute drive.
Age of the child, if you can remind me, or the children.
I believe he's 15.
15. Mm-hmm.
That's right. Okay. Okay. Let's see if the parties, I think as far as the exchange with the domestic violence protection order ending, it should I'll have the exchange be at the home or homes.
All right. With that change, we're in agreement with the rest of the proposed orders.
Great. And I have those proposed orders here, and I'll make that one adjustment as to the exchange location.
And yes, I will send Ms. Bliss my client's address.
Okay, very good. And Judge, yeah, that's just the only change would be in that section 12. You can essentially just strike everything after parent's home because I had differentiations in there for if Eric is transporting one and then the other. So just striking out the remainder of that one sentence. And I think that should be sufficient.
Okay, let's take a quick look at that in 12A.
Oh, and then maybe 12A as well. I do refer to that as well.
Yeah, so 12A, let's look at that. It says, if Eric is attending visitation, he shall provide transportation to and from visits for both he and Alex. If Eric declines visitation or terminates visits early, Alex shall be exchanged at Robert Gray Elementary School. So
I guess striking that and then just handwriting in at each parent's home.
Okay, and then under just 12, it says the children will be exchanged for parenting time, picked up, dropped off at each parent's home if Eric is transporting, or Robert Gray if parents are transporting. So just strike after the or Robert Gray.
Correct.
Ms. Bliss?
No, I would think you would strike after home before if Eric is transporting, because I think the intention is regardless of if Eric is transporting or not, then it would be.
So
we're not going to be transporting at Robert Gray any longer, I would say. So I think that it's important to at least put in there, given Your Honor's ruling, that Robert Gray is just taken out in its entirety.
Yeah, just remove Robert Gray, right?
Correct.
So yes. It reads that it'll be at each parent's home.
Yes.
Okay. That's stricken with initials, and I'll sign off on all the proposed orders that were submitted.
Very good.
Thank you.
Appreciate it.
Thank you, Judge.
Your Honor, Noel plaintiff hearing on behalf of the petitioner, Roy Daly, and I believe Mr. Daly is also present.
All right, very good. Thank you. And Ms. Shariah Nelson, are you on the line?
Yes, I am.
Okay, I see that Ms. Schaefer, family court investigator, is also present. And Mr. Daly, just if you can confirm your presence just by saying I'm here or good morning.
I'm here, Your Honor.
Okay, great. Thanks. All right, we were here last on June 12th regarding the supervisor, and we're looking for some updated information related to that and any domestic violence, or pardon me, yeah, any evaluations related to UAs or SUD.
So I can update the court as to all of those things. at our last hearing in front of Judge Warning, he sent us over to talk about potentially changing the supervisor, as both Ms. Schaefer and my client had expressed concerns about the existing supervisor. We did submit a declaration from my client on June 25th that included a signed supervision oath by his stepmother, Courtney Daly, who has reviewed through the terms of the court supervision order. The only difference in the supervision oath that is submitted is that at paragraph 13 under other, I've provided that the supervisor needs to produce within 5 days of each visit, visitation notes to all parties and their attorneys that talks about the, excuse me, the dates and times and locations of the visits, the supervised parents' parenting strengths and or weaknesses, and overall nature of the visits between the supervised parent and the child. Otherwise, my order mirrors the court's pattern form order that has been, or pattern form oath that's been adopted by Cowlitz County Superior Court.
Do you have any concerns about that? The recommendation from their end is as far as a different supervisor, since there was concerns related to Ms. Hargrave, that person being the stepmother, Ms. Courtney Daly. Do you have any input on that?
I personally would like it to be a professional supervisor and not a family member.
Ms. Hargrave, was she a professional supervisor?
She used to work for the courts as a paralegal.
Okay. Okay.
Which is why I recommended her.
Okay. Okay. Any other concerns if Ms. Courtney Daly would serve as that, in addition to the being family?
I just think that with it being a family member, you know, there are, I guess, ways that she can alter the visitations, and not fully write down information that is needed, especially when he shows up under the influence. You know, it is, I feel like, a conflict of interest with her being a family member.
Okay. Ms. McLean?
So I would note that right now, under the existing supervisor, not only will she not return my calls, of which I've left her 3 messages, but she's provided absolutely no notes or feedback. She had inconsistent dates. I've provided information to Ms. Schaefer that was not supported as far as her requirement to terminate a visitation if there was a concern that he was in fact intoxicated, which my client denies. And the actual oath itself would require Ms. Daly, Courtney Daly, to terminate the visitation if there were any of those concerns. So at this point, Ms. Nielsen has not provided another proposed supervisor. Ms. Hargrave was not a professional supervisor. My client was not required to pay for professional supervision. And I think that we need to move forward with Ms. Daly providing that supervision.
Thanks. Ms. Nelson, do you have any suggestions of who that person could be as far as supervisor?
At this point in time, I have been trying to find a professional supervisor, but I don't know of any right now. I know I had talked to Ms. Schaefer about professional supervisors, and like I said, I've done research and I'm unable to find one at this point in time, but I do not condone Courtney as a supervisor because of her being family.
Okay. All right, thank you. Ms. Schaefer, do you have any input?
Your Honor, I did speak to Ms. Nielsen about other options. I did give her an option of here in town, but she chose that professional to not be adequate at this time. And she was looking into other supervisors. I do share her concern with it being a family member of his, because it does mean that that person could allow him, and maybe if there was some sort of parameter set up of what that person should be looking for to determine if he's under the influence, that might make Ms. Nielsen feel a little bit better if it was to move forward with that family member.
Thank you. All right, so the supervisor that was previously functioning wasn't necessarily functioning as expected and hoped for. So there needs to be a different supervisor. That obviously the safety of the child is of utmost concern, and there's from hearing from Ms. Nielsen, the concern isn't so much that as far as safety, but more of kind of just shading things or maybe leaning more towards Mr. Daly and viewing things in maybe a favorable light to him, but not necessarily an indication that their safety or ability to keep the Paisley safe would be compromised. There's also the issue that if the oath of visit supervisor is violated, then that person could be replaced. So without hearing a viable alternative and the need for that supervisor to be in place, I'll approve Courtney Daly at this point in time, well, recognizing there may be some inherent limitations as far as potential, seeing things through a particular color of glasses. But I think that the base value of that supervisor's position is providing safety, and I think that will be provided.
All right. In regards to answering the court's other questions, we did file on June 20th the negative UA results. My client on Monday completed the second session of the evaluation for substance use with the tribe on Monday, including a UA. He's still waiting for their actual evaluation, but they've scheduled him to start whatever their treatment recommendation is on Thursday this next week. In regards to domestic violence, we have filed under seal the evaluation from from Sam Case, who's with Ms. Lovely's office. That was filed on June 11 of 2024. Mr. Daly, and we communicated with Mr. Case that Mr. Daly wanted an opportunity to see if the tribe could provide those services for him that were recommended at minimal or reduced cost compared to what was being identified as far as the cost from Olivia Lovely's facility. The tribe apparently does not provide that service. So he's reached back out to Mr. Case. And as you heard earlier on this docket, Mr. Case is on vacation until this next week. So the anticipation is that my client would be in contact this next week to get on the schedule to start that treatment.
Thank you. Ms. Nelson, anything related to that?
Yes, as far as the UA that he recently just did, from my understanding, when he did the hair follicle test, he tested positive for cocaine and THC. Now, from my knowledge, cocaine stays in your system for 90 days and THC stays in your system for at least a month. There are ways you can alter a UA. So for him to test negative a week later on a UA just doesn't set right with me. I would personally like him to do another hair follicle test and go based off of that.
What was the date of the first hair follicle test you mentioned?
The first hair follicle test was June 4th, and so it wouldn't be viable for another hair follicle test for 90 days.
Were those results submitted to the court?
Yes, those were filed on June 11th. And Judge Warning reviewed those and ordered that Mr. Daly was to produce a clean UA. Again, because knowing that once you've had a hair follicle, you have to wait 90 days until there would be another valid hair follicle because the results would be the same. And so he ordered the UA, and once the UA was submitted, then visitation would resume. That was filed on June 20th, and visitation has resumed. The supervised visitation.
Ms. Schaefer, do you have any input?
Your Honor, no, sorry.
Okay, all right, thanks.
Your Honor, I would like to say something. From Ms. Schaefer's report, Roy had told her that he doesn't do cocaine and has never done cocaine. And then when he did the hair follicle test, he tested positive for cocaine. And that was one of my concerns of Paisley's well-being during the visitations, was him showing up under the influence and putting her at risk.
Understood. So back on June 12th of the last hearing, the court indicated that if there's a clean UA result, then the supervised visitations could resume, and that there was a clean UA. I recognize there are some limitations to UAs, but I think that burden's been met, and so the supervised visitations can resume.
Is there any way that he can do another hair follicle when time is due?
You could certainly bring a motion, you know, it's 90 days roughly is kind of the time frame that hair follicles are viable. So I won't make a prospective ruling on that. You know, if a party files a motion, we'll certainly take a look at it. I think those are the items that were addressed and needed to be addressed today. Any further items, either Ms. Nielsen, Ms. Schaefer, or Ms. McLean?
The only other thing that I would note that in my client's declaration, he indicated that he has no objection to an order that restrains his use of alcohol substances prior to or during his residential time, and that he is following through with the treatment recommendations. And once we get the evaluation, just like I did with the domestic violence evaluation, I'll get that filed and circulated to all the parties. And then the only other question I would have for the court is, are you tasking me to prepare an order? And if we need to schedule a follow-up, or is Your Honor entering a handwritten order?
Yeah, handwritten order, I think, is what we'll do here today.
Okay.
So the handwritten order will indicate that Courtney Daly is approved as a supervisor. That'll be the first item. I'll note that here.
Your Honor, I do have a couple questions.
Go ahead.
When would she start supervising the visits?
His next visit is tonight.
She's appointed as of now.
And I will circulate the signed oath so that both Ms. Schaefer and Ms. Nielsen can sign that. I'll circulate the one that's been signed by Ms. Daly and my client, and I'll just send that to them through Dropbox Sign so they can electronically sign that, and then we'll get that filed with the court.
And then also, is there any way that we can reverse the agreement of email services and make it paper copies, as having it in paper definitely helps me a lot better, especially for court hearings?
I'm happy to provide both email and follow it up with a mailed copy if that's Ms. Nielsen's request.
Yes.
I don't have any problem doing that.
Okay. And then if I also didn't receive a phone call while I was in class from the court clerk, I wouldn't have known that there would have been a court hearing today. I didn't receive a docket notice or anything based on this hearing today.
Well, we were in court on the 12th. I don't think that Ms. Nielsen was present in court on the 12th, but she was in court with Your Honor, who was covering for Judge Hahn on June 11th. And at that time, we referenced the hearing on June 12th. And it was at that hearing then that it was set over to today. So she's found out some way because she's here.
Yeah, because I talked to the court clerk over the phone.
So yeah, I'm not exactly sure what happened, Ms. Nielsen, but you're here today, and I apologize for the oversight. I'm glad you were here. So we have Courtney Daly is approved to serve as supervisor. Petitioner, Mr. Daly, shall not consume alcohol or other mind-altering substances 24 hours prior to his residential time with child.
Or during.
Or what?
Or during.
Oh, pardon me. Thank you.
Yeah.
And then this order, other items that it should or should not include. I should indicate that supervised visitation can now commence.
And would you mind also including in there that my office will provide a mailed copy as well as emailed service to Ms. Nielsen?
Yes.
Thank you. I appreciate that.
So attorney for petitioner shall provide service of all documents via email and paper copies.
Thank you.
Any final items from any of the parties?
I will provide a conformed copy of the order that Your Honor is entering to both parties. And as soon as we're off the line, I will forward through Dropbox sign the oath for them to sign and then provide them with a conformed copy once that's entered.
Very good. Ms. Nelson, do you?
Would Courtney start supervising as of this weekend?
Yes.
I thought that visitation was Wednesday night.
From my understanding, he is out of town.
So she's
Yeah,
approved it as of right now. So whenever that date is, she can start doing that.
All right, thank you.
All right, that'll conclude there. Thank you. Is Monet Marquez on the line?
Yeah, I'm here.
Welcome to you, Ms. Marquez. And is Spencer Secy on the line today?
He's not. He's currently at work right now.
Okay, Spencer Secy, if you're on the line, if you'll state your name and so I know that you're here or not here. Spencer Secy. All right, there's no response. And looking at the participant list, I don't see him listed therein. So you indicated, Ms. Marquez, that he's not present, he's working, and this is his motion.
Yeah, this is his motion.
Was there any communication between the two of you as far as what the next steps were with the motion?
So we had previously made plans after our last hearing to come up with a date and a time to meet in person and come up with a plan that we both agreed to. Everything's been going smoothly. However, he had a medical emergency of some sort. So we weren't able to actually sit down and have that discussion. I've talked to him since then, and it looks like he's got a new place of employment. So he's got a completely different work schedule than he had before. And he's been dealing with some things at home. So we still haven't sat down and talked, but that's the plan to do so. He verbally said that I could tell you he either wants a continuance or just to strike it completely. He's not really sure how it works either. Neither am I.
Okay. There's two ways to approach a pending motion. One is to strike it, or the other is to continue it. Here, it looks like there was we're still waiting to hear back from Ms. Marquez on what her input is related to that motion. And with a change in, it sounds like from Ms. Marquez's viewpoint that Mr. Secy has indicated that he has a different workplace, different employment schedule. So I think at this point, and he's not here, so I don't know exactly what his viewpoints are related to a continuance or striking. He was aware of today's hearing. I think we were here last, let's see when that was.
The 20th.
All parties were here on June 12th, and we set over to today. And I'm not sure why. I'll double check with the court clerk's office if you received any messaging from Spencer Secy about whether he's coming or not coming. Yeah, thanks. So he had notice of today's hearing, and he's not present, and we'll still check to see if he communicated anything to us about that. Okay. Court clerk's indicating that she's not seeing anything. So I think at this point, I'm going to strike the hearing. If the parties want to note it up again and address the same issues that have been previously filed, we could do that. But at this point, it's stricken, so it's lying dormant until somebody revives it. So it's kind of done at this point unless somebody pulls it up and runs with it or has a different motion filed.
Can I ask you a question, Your Honor?
Sure.
So we've kind of come to this agreement verbally. It's been talked about a little bit of every other weekend. Would we need to refile another, what would you call it? Change of the parenting plan to put that new schedule in, and we could do it together?
So if there's nothing that prohibits a party from two parties agreeing to a certain outcome. So if the parties agree to some outcome, i.e. a parenting plan, then both of you, if you so agree, could sign an agreed order of adequate cause and an agreed parenting plan.
Okay.
Yeah. Okay.
All right. Thank you.
Thank you, Ms. Marquez. And if you just do me a favor and make sure the microphone is close to your mouth. It does not amplify, it does capture for recording purposes.
Okay.
All right, that looks like Ms. Camarena is coming forward. All right, and you're Rocio Camarena?
Yeah.
Okay, very good. We'll let you take a moment to get settled. And also, if you could just make sure you're positioned close enough to the microphone that'll capture your voice. I'm not sure if that one's affixed to the table or if it's movable. Yeah, okay, it does movable, but thank you, appreciate that. All right, so we're here on a motion brought by Mr. Connor related for a restraint or a restraining order of some type related to the children. Before we get started with that, I just wanted to check with Mr. Connor regarding service. You may have heard me discuss earlier the service of documents and due process and the like. When I checked yesterday evening related to if there was proof of service that you'd served a copy of your motion on Ms. Camarena, I didn't see one. So where do you stand with that?
I didn't fill and file one out. Wasn't sure.
Oh, okay. Okay. Yeah. So as a general rule, that's required, is that there needs to be some proof in the file that says, hey, on such and such a date, it wouldn't be you, it'd be somebody else, served or sent documents to Ms. Camarena. And these are all the things I'm saying. And she knows exactly what you're saying. And then she would have an opportunity to respond to that. And she would also have to fill out a declaration of service, say on such and such a date, one of her associates served you or mailed those documents to you. So that's kind of a baseline rule. That's a threshold rule before we can move forward with the hearing. And I apologize, it's coming 2 hours and 36 minutes into a very long morning for you all. But I think that what that means is that we don't move forward today, that there has to be that declaration of service showing that the documents were served upon Ms. Camarena. So I think that's where we're at. So wonderful. I'll hear from you if either of you have any questions.
Yeah, can I clarify? So if and when I get served, then I have to respond to that with what's it called?
So generally, if Mr. Connor has documents and he's kind of laying out his cards. He's saying what he thinks is important, what he wants, and he's done that in declaration form. So usually people will reply. If you want to say something in response to that, you would fill out a declaration of Rocio Camarena.
Okay.
And then you would send a copy to him. You'd have one of your associates send a copy to him or serve him a copy of that. And then that person who's doing that service would fill out that proof of service or declaration of service and have that filed. So everybody knows. So the court knows that everybody has all the same information and that's needed to move forward.
Okay.
So at this point, I think what we'll do, we'll strike the hearing. Then Mr. Connor, you'll be in a position to serve Ms. Camarena with those documents that you filed. And then file that proof of service, and then you'd be setting up a docket notice or setting it for a future date, and then giving notice to Ms. Camarena of that date and time. So it's kind of disappointing news, and I apologize for that. So any other questions, Mr. Connor? Okay, Ms. Camarena.
No.
Okay, all right. At this point, we'll wait for the parties to take additional action. I'll ask if Heidi Ellis is on the line.
Yeah.
All right, and you're being represented by Mr. Ball, I believe.
Yes.
Okay, Mr. Ball is still online. Thank you. And then is John Ellis on the line today?
Yes, sir.
All right, welcome to you, Mr. Ellis. We're on today for presentation. I read the objections filed by Mr. Ellis, and he raises some good points related to our local rule indicates that all proposed orders will be prepared and filed by the moving party. And he expressed concern about that the court had asked Mr. Ball to prepare that. I think his request is fair. So what I'd like to do is if Mr. Ellis wants to prepare a proposed order of what the court's decision was from May 15th, I would entertain that. He could send a copy to Mr. Ball, and then we would have both proposed orders before the court. I think that seems reasonable and it seems proper. And so that would, and I'll just ask Mr. Ellis if you have any questions about that and what timeframes you would need to do that.
I can certainly prepare the order as you ordered it. It would not, of course, include some of the extras that the opposing party put in there. I would ask for the typical 2 weeks or 3 weeks, whatever it is. It won't take me that long, but I still have concerns, as you read in those objections, about how I'm going to meet what the court ordered based on the reduction in time and the supervisor's schedules.
Noted. Noted. July 17th would be 2 weeks. I'll check with both parties to see if that would be workable.
July 17th is fine by me.
All right. Thank you, Mr. Ellis. Mr. Ball?
Yeah, I'm available that day. I guess my only concern is now this is, I think, the third hearing we've had on the entry of orders. So that's what my concern now. We've spent a lot of time on this, and okay, if that's fine, that's what you want to do.
Yeah, understood. I appreciate the concern related to the timeliness of the entry of the order. I think given those proposed, the objections to the proposed, I think that's a fair consideration. And so we'll come back on July 17th. Mr. Ellis will have served a copy of his proposed order from the May 15th hearing to Mr. Ball, and then we will be back on the 17th to flesh the respective orders out and enter an order.
I did have a point of clarification that might help us along, and then and that I think we didn't describe who's going to pay for the reunification counseling or how that's going to be paid. So that's one thing that we're going to have to decide. So anyway, if you want to make a ruling on that, that might further us along.
I think as far as we're here on presentation from a May 15th hearing. I don't think the court had indicated of what the payment parameters are related to that.
Yeah.
So if we address it today, I'm not exactly sure what information the parties would be using as a foundation for the requests. Mr. Ball, do you have any idea on that?
Well, I guess it would either be, the options are that it's going to be shared either 50-50, it's going to be shared pro rata, or, I think oftentimes it's the parent that's going through the counseling pays the entire expense. Pro rata based on the child support worksheets.
Okay. All right, Mr. Ellis, do you have any input whether the court makes a decision on that today or waits until the 17th to make a decision on that?
Well, honestly, Your Honor, I realize that this is supposed to be presentations, not making a new order, but I agree that what was ordered is not achievable even as it was ordered. And part of it is around those financials. The court's family support order, combined with the other orders that the court has made along the way and additional responsibilities they left with me, now totals 125% of my income. And that is not counting for any of my personal life support needs. So out of those three options, I would go with the prorated, which is about roughly 35% mine and the rest Heidi's. But I still don't know where I'm going to come up with it.
Okay. All right. Thank you. I'll set it at a 60-40 split, 60% Mr. Ellis, 40% Ms. Ellis for the reunification counseling, recognizing that there's concerns expressed by Mr. Ellis about his ability to meet all the needs that are imposed upon him. All right, we'll go back on the 17th of July.
Does that also apply to the professional supervision that was never ordered by the court?
So this is the difficulty that we encountered when we kind of opened things up. We're here for presentation. I recognize that. So both parties indicated it'd be helpful for the reunification counseling cost to be addressed. If you feel that would aid in the presentation docket or hearing on the 17th, I can address it, recognizing I haven't spent much time thinking about it.
Then I would like you to get time to think about it. Can we do that?
Oh, could you repeat that again?
Then I would like you to have time to think about it. Can we just present it exactly as the May 15th order was, and then we figure it out there?
Mr. Ball?
That's fine. Thank you.
Yeah, let's do that. Let's address it on the 17th, and we can go from there.
Okay, and that's for the reunification as well, or just for the professional?
So for the costs of the reunification counseling, I've addressed that today.
Okay.
As far as the other, that would be on the 17th.
Okay. All right. Thank you, sir.
All right. We'll see everybody then. Thank you.
Okay. Thank you, Your Honor.
I'll ask if Michelle Guajardo's on the line.
Yes, I'm here.
Okay.
Your Honor.
All right. Welcome to you. And then is Mr. pardon me, Humberto Guajardo on the line?
Yes, Your Honor, I'm here too.
Okay. Welcome to you, sir.
Thank you.
Stay on Mr. Guajardo's motion for adequate cause and also his petition to modify a parenting plan. I see that service was proper, that documents were served to Ms. Guajardo on June 14th. And so it looks like all the necessary documents that were required were served upon her. However, the time frame was on June 14th, bless you, June 14th, which is less than the allotted time under court rule. So I just want to touch base with the parties on that. I read, if I'm not mistaken, let me just pull it up again here. Bless you. The concern I have is that I think number one, Mr. Guajardo submitted all the necessary paperwork to Ms. Guajardo. She received it. However, the timeframes were not long enough from the time of service until the time of hearing. And sometimes that's difficult because service sometimes doesn't happen quickly. Sometimes it's delayed. So I see that I've read everything that Mr. Guajardo wants, but I've not received anything what Ms. Guajardo's thoughts on the matter are. So because there's not that sufficient amount of time, my thought was here today to not go forward because that time in between service and the hearing wasn't enough, and that would allow Ms. Guajardo to file a response, and then we could have a hearing at a later date and time. So
Can I
go ahead?
Sorry, I just want to note that I did file a response as of yesterday. There were a few setbacks that did cause delay. For example, I got my forms from the Cowlitz and Wahkiakum Legal Aid, and several of those were expired, so I had to redo them when I filed. And then because he does live out of state and due to the 4th of July holiday, I filed online to have him served, and that has also been a little delay just because of everything and the time frame. But I have been working on this, and I do have a response.
Okay, thank you. And yeah, I appreciate the fact that you filed something. Sometimes there's a delay in processing. It just takes some time to process everything. So it hasn't hit the court file officially, not that I can see at this point, but I trust what you had indicated. So Mr. Guajardo, so what we're looking at is setting the case over for the court to consider not only your viewpoint, but also Ms. Guajardo's viewpoint, and then make a decision. Do you have any questions about that?
Yeah, Your Honor, I understand that, and I totally agree with that. My only objection that I have a problem with is Ms. Guajardo she knew that we had a family reunion, and after she got served, she struck out. She's been unresponsible with me calling the kids and letting me talk to the children. She made a point that the family reunion that I was leaving on a Thursday, that we'd already verbally agreed to these things, and that it's a 6-hour drive for the family reunion. And she told me that I couldn't pick the kids up until Friday, when the family reunion had already started in the evening time. And she's been vindictive with the kids. And so I have heard very little from my children. And when I have talked to them on the phone, she hangs the phone up. And like this weekend, and she also knows that I'm on vacation, and that I've made plans for the children to go camping with the kids. And she's only had the children one 4th of July in the last 9 years. And normally the 4th of July is a very special holiday for me and our children and our family. And she's unresponsive to that too. So she's using the kids.
Yeah, so anytime that there's concerns related to what's happening with the children and parenting time and the like, we're not going to have a hearing today on any of the issues, but if there's concerns, then certainly when Ms. Guajardo files her response, then you could file a rebuttal or a reply with any concerns that you might have. In that way, each party is able to see what the other is saying. Each party is able to reply to what the other is saying. So what I'm proposing is that we'll set the matter over to the 17th of July, which is a Wednesday at 9 a.m. to hear the motion. And that would allow that's allowing enough time for everybody to respond. So Ms. Guajardo has filed her responses. And Ms. Guajardo, did you provide copies of those documents that you filed to Mr. Guajardo?
Yes,
Yeah,
I did, Your Honor. When I filed to have him served, I included copies of all those documents.
Okay, all right. And then Mr. Guajardo, after reviewing those, if you want to submit something in reply, you're certainly welcome to do that, and just make sure Ms. Guajardo gets a copy of those. So we'll be back on July 17th, 9 a.m. to review everything and make some decisions.
Okay, and Your Honor, am I able to go in person in the courtroom and do this, or is this on Zoom only?
Everybody's welcome to come in person. If you want to do it Zoom, that's fine also. No preference on this end.
Okay, I appreciate that.
Okay, Ms. Guajardo, any final questions?
Yes, I just want to say something.
Do
Normally,
you have any questions?
children,
Do you have any questions?
He is not scheduled to pick up the kids until Friday the 5th. He is asking additionally for the 4th, and
What's your question?
like, he still be able to have them even though it's not his scheduled visitation time? I mean, I am trying to do the right thing.
Yeah, so today we're not making any decisions related to any of the pleadings or requests. And so I recognize that probably puts the parties in maybe a difficult position if there's not agreement or there's disagreement on visitation. At this point, I'm not making any decisions related to the residential time.
Okay.
So we'll see everybody on the 17th.
Thank you, Your Honor.
If Drama Tatum is on the line. Ms. Tatum, are you there?
Yes, I am, Your Honor.
Okay, welcome to you. And Robert Tatum, are you on the line? Robert Tatum, if you're on the line, please state your name so I know that you're present. Okay, I'm not seeing anybody on the Zoom participant list that would be reflective of Robert Tatum. I'll just double check. Oh, are you going to get Mr. Tatum? Oh, okay. No, he's not. Okay. Sorry. I'm just taking a quick look at the docket notes from when we were here last, which was on June 5th. We were present. Mr. Tatum was present. Ms. Tatum was present. It was set over to today, July 3rd at 9 a.m. He had received notice of that. Ms. Tatum, have you received any communication from Mr. Tatum as to his whereabouts this morning?
No, I have not. He has violated, in my opinion, the order, but not in Kelso Police's opinion, my protection order.
All right,
but I have not heard anything about today.
Okay, thanks. And there's nobody, Robert Tatum's not in the courtroom. So at the last hearing, the indication was that Mr. Tatum needed to file proof of his SUD treatment compliance. And if he hadn't, then his outstanding motion for a temporary order that was filed on February 28th would be denied. He was wanting some residential time from Saturday to Sunday. When I checked the file yesterday and again checking it today, nothing has been filed. The indication from June 5th was that if he filed something, we'd take a look at things, but if he had not, then the motion would be denied. So I'm denying the February 28th motion for temporary family law order. I'll do a bench order to that effect. One moment. All right, Ms. Tatum, I signed an order that reads the following. Respondent's motion, Mr. Tatum, his motion filed on February 28, 2024 is hereby denied for respondent's failure to file proof of his compliance with substance use disorder treatment. If you need a copy of that, you can check with the clerk's office. Otherwise, that will be filed. Do you have any questions?
No, I don't. Thank you, Your Honor.
All right, that'll conclude there, and thank you. Allow them to come
Thank
on
you.
up. Okay, are you Mr. Penn?
Yes, sir.
Okay, welcome to you. And are you Ms. Penn? Okay, welcome to you. All right, so let me just touch base with the parties. So first off, I want to make sure I pronounce your first name correctly. How do you pronounce your first name?
Sochia.
Sochia. I'll go to the CH sound. Thank you. Okay, so Mr. Sochia Penn's here and Ms. Shannon Penn is present. We're here on Ms. Penn's motion related to temporary orders, including parenting plan and child support. And let me just double check with Mr. Penn. Did you receive copies of her proposed orders and motions?
No, I did not, sir.
Ms. Penn, did you serve documents on Mr. Penn?
Yes,
Okay. Did you file a proof of service?
yes,
And when I looked at that proof of service, it indicated that you yourself served those documents on Mr. Penn.
yes.
So that's an issue for under the court rules. And you may not have known this. It seems intuitive for a person to file, if you're the party, to file those other documents on the other party. But what the rule requires for service purposes is that it be a third party, not a litigant. So you're technically a litigant. And so anytime that you're serving papers on another, on Mr. Penn, you'd have to have a third party do the service. So with that defect, it prevents us from moving forward today. And just the rationale behind that rule is that the idea is that if there's a third party serving the documents, there's not necessarily as great an opportunity for a party to say they did something that when maybe they didn't do something. I'm not saying that that's the case here, but that's the rationale behind it, is that a third party signs under penalty of perjury, and there's a greater likelihood that that's going to be accurate without any discrepancies or distortion. I recognize that you all have spent 3 hours here this morning, but as far as today, moving forward, I think service is improper. So in order to correct any deficiencies to have proper service, there needs to be service of documents via a non-party that would be effectuating or giving the documents to another. So that's a long way of saying that the hearing today is not going to go forward until there's been proper service. So once proper service has been achieved, then that would allow all parties, that would allow Mr. Penn to file his response, and then you could file a reply to that. But without the proper service, we're not in a position to move forward today. Ms. Penn, do you have any questions about that?
Is there any way I can, have him served here while we're here in court today?
However you or another wants to figure out how to do the service. I'm not one to give guidance of how that can happen. Service can happen in a variety of ways. It can happen personal service through a third party. It can happen in other ways also.
Okay, yeah, I was told that because we live in the same household, it would be okay. So, okay. I'll do
Yeah,
that.
unfortunately, it's not accurate.
So, what happens now?
So the hearing today would be stricken. There'd have to be a proof of valid service filed, and all
For the
the
paperwork I've already done.
Right. So all the paperwork that has been served would have to be reserved upon him by a third party. That third party has to file a declaration of service or proof of service that they served it on such and such a date at such and such a time. And then once that's accomplished, then you can set a docket, set it for a docket for a hearing, and then send a notice to Mr. Penn of that. And then that puts him on alert of when he needs to get his documents in, his reply and his perspective, because I don't know what his perspective is at this point. So I need to have both perspectives at play.
Okay.
Mr. Penn, do you have any questions?
Yes, I do, Your Honor.
Go ahead.
As far as my divorce paperwork go, she's been served. It's been like, I'm all new to this stuff. I don't know anything about the system, but she has been served and I have not get no response back according to what I was asking as far as separation go, and it's been a long time.
Okay. So yeah, as a general rule, it looks like you filed your petition for dissolution back in April. And then also as far as the service, it looks like there is a proof of, let's see, did you file a proof of service that you filed those documents on her?
I did, Your Honor.
Okay, so I'm just taking a look at that. So in general, what happens is that once a party files, so one party files a petition and the other party gets served, then the other party needs to respond to that petition, whether they agree with it or disagree with it. And there has to be a response one way or the other. If there's not a response and there's proper service, then the party asking for a petition could file for what's called a motion for default. And a motion for default says, hey, I filed all this paperwork timely. I haven't heard from the other party.
My response has been here.
Okay, so you filed it?
Yes.
Okay, so if there's a response been filed, that means that there's a controversy, right? There's not a meeting of the minds, so that means that the case is going to move forward. So at this point, if there's been a petition filed and a response given, then either party is free to bring a motion for temporary orders or for temporary relief. And if the parties want to just note it up and go straight to a trial, that's an option also. A lot of times people want some temporary relief and they need it more quickly than a trial could afford.
I just want to be done quickly, Your Honor.
I think everybody does. I think everybody does in these instances. It's hard, it's trying, it's very difficult to say the least. So in response to your question, once there's been a case filed and there's an answer filed, there's two ways to resolve it. One is through agreement and the other is through a trial. So that's kind of where we're at. So I always tell people that if you all are much closer to the issues, you know the history better than anybody. So if you all are able to come to an agreement, great. If you can't, then you come back to court and then the court would make a decision on those issues. So
But I have not yet seen the response, the paperwork that she's been served to. I haven't got a copy of it. I have never been served by her.
Okay. Well, that's something that I'll allow the parties to kind of take a look at that to make sure that that's been completed. You might want to double check the court file to make sure that there has been that answer.
He handed them back to me.
Pardon?
He handed them back to me.
Handed the
paperwork that
Your
I
Honor,
served for today.
I thought there was like third parties supposed to be doing it.
So I'll go down today to the sheriff's office and just get it served.
Okay. All right. So, I mean, that's kind of the lay of the land at this point. There's been a divorce action filed. And if that can be resolved, as I said, in two ways, either you agree or you go to trial. If you can't agree and you need more rapid kind of resolution of issues, then motions for temporary orders would be filed with proper service and the like. And so that's kind of where we're at this point. Ms. Penn has filed that motion for the temporary orders. And so I just encourage everybody, if just to verify, to make sure, look at the case file and make sure that you have filed a response.
I understand.
And then make sure that you serve Mr. Penn properly. And then if you get served properly, Mr. Penn, then you would submit your version, what's your perspective, and then serve a copy to Ms. Penn so we know where everybody stands. Then we'd come back on a particular date that's noted by one of you, as usually it's the moving party. So Ms. Penn, you filed the motion, so you'd likely be setting a date, giving enough notice and time for Mr. Penn to respond. And just look at local rule 88. You can look at the Cowlitz County Superior Court website, look under local rules, and look under rule number 88 for timeframes. So without proper service here today, we're not going to move forward today. So I'll strike the hearing today, allow Ms. Penn to do what she needs to do as far as service, and allow Mr. Penn to, if served properly, to respond properly. So questions at this point?
No, sir.
Okay. Ms. Penn?
The paperwork that I served for this hearing, am I able to, do I have to use my copies to give it to the sheriff, or can I use copies that I gave to you that I served him, or how does that work?
He has to receive physical copies. He has to receive physical copies. So however you want to do that, he just needs to have physical copies.
Great.
Yeah. Okay. All right. So with that, we'll be adjourned.
Thank you.
Thank you.